pendency of the civil suit and the status quo order is also operating. Now, during the pendency of this status quo order, my lord, the circle officer has passed an order cancelling the mutation.
He brings to the notice of the competent court.
No, my lord, once the order is passed, given effect, my lord, the civil suit will be infructuous, my lord.
No. Therefore, you bring it. There is an injunction order.
There is an injunction order.
You file an application.
We have filed an application, my lord.
For the injunction order not being complied with. You have the provisions there.
My lord, let me try my luck tomorrow, my lord.
No.
Lordship will consider merits of the matter, my lord.
Luck is dependent on your merit of the matter.
My lord.
So you have the opportunity there. You have a remedy there.
But once the mutation is changed, because there is an order directing the Lat Mandal to give the effect to the order, my lord.
Who's for the respondent? Who are the respondents?
Respondents are the state respondents or private?
You serve copies today.
My lord.
You serve them copies today.
My lord.
We will take up the matter tomorrow, second half.
My lord. I'm deeply obliged.
But you must serve the copies to all respondents.
To the private respondents also, my lord.
Yeah.
Item 56 to 60.
50?
56 to 60. In the supplementary list.
Yes.
Well, I have taken the consent. Can it be on 23rd of July after vacation? Some issues regarding the date. 23rd.
Yes.
Already parted.
Huh? Yes. Do you have any objections to that? You have given consent?
Yes, we have given.
All right. Joint request matter be at the request of 56 to 60.
On 23rd July.
At the request of Council for the Finance Department, that the matter be listed again on 23rd of July.
No.
23rd
Tuesday.
of July. Right.
With the assurance that no further adjournment will.
Yeah, we hope.
Lordship,
Prayer made is not objected to by the council for the petitioner. An attempt will be made to dispose of the petition on the next day of this week.
Lordship, in respect of item number 3 and 3 to 6, Lordship, some accommodation any date after vacation, Lordship.
At the request of Council for the Revenue Finance, matters stand adjourned to be listed again on 30 July.
Any date.
30 July. Dr. Saraf. Our matter. Yes.
Lordship, I have to mention item number 14, Lordship.
Yes.
Lordship, in this case, we will file an additional affidavit, Lordship. And to that effect, we have already collected some documents regarding whether the present petitioner is presently working or not.
We had given liberty on the last occasion, 2012 matter.
Lordship, accordingly, we have collected some documents, but all of are not coming because due to
How much time do you require?
2 weeks.
Weeks. You file it within 1 week. We'll give you 1 week's time.
Obliged.
File it. Item 14 at the request of learned counsel for the petitioner. Matter is deferred again, enabling them to file the affidavit.
Additional
affidavit. Yes.
Well, I'm bringing listing of a matter for motion tomorrow. This matter is connected to the flyover series, which is otherwise listed tomorrow.
What series?
Flyover, Tezpur, the flyover matters, which are connected. And petitioner has already filed one petition which is pending. And because of the amendment
of land.
Lordship, that matter, and now he has filed another petition today. That may come up tomorrow, may be taken up together with the other matters. It is.
You give the number.
Lordship, I'll give it.
Yes.
Double.
May I please, Your Lordship? Here, I am appearing on behalf of respondent number 1, my lord. Saturday, we have filed our affidavit, my lord. This is not tagged with your lordship file, my lord. Also kindly take up this matter some other day, my lord.
Well, this case has got a checkered. But certain lands were acquired under the Land Acquisition Act for the purpose of enhancement of the road condition of NH highway, National Highway. Thereafter, it was handed over to the National Highway Authority. But it appears from the different affidavits filed and from the records of the case that entire acquisition of the different lands were towards the provisions of the Act. But the government in the meantime has retained the land and started functioning. Therefore, in that view of the matter, the Honorable Court, Mr. Justice Devashish Barua, had filed an order, had passed an order on 14/11/2022, taking the cue from the records of the case that since the government is in session of the matter, but the petitioners herein, they want that compensation should be in accordance with the new act, the right to fair compensation, which came into force 1/4/2014 possible. 1/1/2014. But in these cases, all these cases, there were about 6 cases. LA case number 32, 33, 35, 36, 37. These cases were either the notifications were beyond the date or the approval of the award was beyond the date. In that view of the matter, the Honorable Court has passed an order directing the authority concerned whether it wants to retain the land and give the compensation to the authorities under the new act. When that was passed in 14/11/2022, 2 years have gone by in the meantime. Now they have filed an affidavit. They are saying that since it was handed over to ASIDC, NSIDC, National Highway Authority Infrastructure Limited, Development Corporation Limited. Therefore, it is the authority concerned who is to pay the. Now the question is as to who is to pay the compensation amount. Is it the state of Assam or the National Highway Authority? That is the crux of the matter. One respondent is shuttling.
Is it only the authority? Is it that only the authority who has to pay is to be decided, or under what provision? New Act or Old Act?
Under the new act.
That is your claim.
This is just back. And the Honorable Court also.
In view of Section 24.
Yes, Section 20. Exactly.
Yes, your affidavit is to what effect?
My lord, that now the position of the acquisition now in the hand of
You
National
have
Highway.
already acquired the land.
Yes, my lord.
It's already under taken possession.
Yes, my lord. Now it's under the position of NSIDCL, my lord.
So they must have deposited the amount.
My lord.
No, Lord. The land was earlier acquired by the PWD department. Lord. In the year 20. Subsequently, Lordship, land was handed over to the NHIDCL, Lordship. In the year 2020-22, my lord.
So who has paid the compensation?
So state is to pay the compensation, my lord. We have filed the affidavit, and moreover, Lordship, they have filed one affidavit in terms of last order, my lord. That affidavit is also not served to me, my lord.
Have you received a copy of the affidavit, Mr. Das?
Yes, I have gone through it. I can hand over a copy to you also.
So let it come next week along with the copy of the affidavit.
My lord, next week, my lord,
Next week.
either on 25 or to 27, if you are not.
All right, 25th. 25th,
25th. মঙ্গলবার,
Yes.
মঙ্গলবার।
PR
Wahid.
Monto, learned standing counsel for the revenue department, submits that an additional affidavit has been filed in the matter.
June, next week.
However, the
না,
same
না, 25th. মঙ্গলবার।
has been filed on that Saturday. I think it is 15th. However, the same is not recorded. Matter be listed again on 25th of June.
Huh?
Registry to trace out the affidavit and connect it to the case file.
এইকেইদিন ৰাজীৱ নাথাকে তাতে ৰাজীৱে কৰিব
অ, কৈ দিয়ক, কৈ দিয়ক।
তার আগত করু,
Mr. PC Das.
তার আগত করে তো
Senior
idea
legal
হবে।
appeal for the petitioner assisted by Mr. A. Shah.
তাই জন্য হোমওয়ার্ক।
স্যার, আফটার ভেকেশন করে যাই, ইমিডিয়েটলি আফটার ভেকেশন।
List accordingly. Yes, 25th.
না, মই আহিব নোৱাৰো।
তাতে আফটার ভেকেশন টাইম।
নাই, মই আহিব নোৱাৰো মই। 25 তাৰিখ 27 তাৰিখে আহিম, মই দুদিনে আহিব নোৱাৰো।
আফটার ভেকেশন টাইম।
After
Lordship,
vacation,
let it be on after vacation, my lord, because some senior counsel has some problem in 25 months.
Only on 25th I have a difficulty, Lordship. Because
All right, matter will be listed after vacation. On a date fixed by the registry.
All
15th July.
You confirm and give it to the court master.
Yes.
Yes, we are confirmed.
May I please, Lordship? Kindly pass over the matter for the time being, Lordship.
What is the matter?
My lord, kindly have a look on the last order, 24 May 24. Compensation area rent. And lordship has passed this order in the light of my lord. Order passed by this honorable court on 5/1/2024. Detailed order passed by this honorable court. And thereafter, my lord, this honorable court on last occasion 24/5/24 this order passed.
Yes,
Lordship, my senior is in legs, Lordship.
who is your senior?
Ega and Lordship.
This caller, we are adjourning, keeping it aside for time being.
Lordship.
This caller.
My lord, regarding acquisition of land and compensation by the National Highway Authority of India. My lord, in this case, what happened, my lord, the land is my husband's ancestral property, my lord. My husband has been suffering from various diseases. Now he is bedridden and reduced his memory also. Anyhow, my lord, the land measuring 2/12 lesas situated at the Village College, this is Dima Hasao, my lord. What happened, my lord, on the western side of the land, I have submitted photograph also. On the western part of the land, they have acquired, my lord, long back, my lord, before 20 years back, my lord. My lord, we shifted, they dismantled our residential houses, then we shifted to the eastern part of the purported road, National Highway. We constructed houses with concrete pillars. Now they said that on 4th of May 2023, the respondent means National Highway Authority entered into the premises and erected 4 pillars saying that the land will be acquired for National Highway. So you vacate the land forthwith. So immediately I approached the authority, my lord, National Highway as well as Revenue Department. I submitted a request letter. Then, my lord, I have been paying land revenue, my lord, till April 2023. And land measuring to Kotha 12 lists covered by DAG number, Kota number 68, DAG number 18. That is, my lord, page, paragraph, page 13, annex 3 of my writ petition. And 1 and 2 are my request letter. That is received from Ramakanta Kampre, that is father-in-law, son of so-and-so, college this is summer rupees 18 only, an account of LR for the year so-and-so. Now, my lord, we immediately approached this honorable court, and this honorable court protected me by passing interim order. Now they file affidavit, my lord. What they say in the affidavit, my lord, the respondent number 3 file affidavit, my lord, and in my lord paragraph, paragraph, my lord, 5 of the affidavit, page 2. With regard to the statements made in paragraph 3, 4, 5, and 6 of the writ petition, the contents made by the petitioner are categorically denied, and it is most humbly submitted before this honorable court that the writ petitioner is the wife of Ramesh Kampre. In this regard, the answering respondent humbly begs to state that the petitioner's husband received compensation amounting to rupees 6,80,000 for the land acquisition, including land value, jirat, etc., and building compensation. The compensation was issued by check number so-and-so payable to Sri Ramesh Kampre, the petitioner. My lord, on what date they paid the amount and how much amount in the check that has not been mentioned, no such documentary evidence, my lord. When they paid this amount, there is no such authentic documents. Then, my lord, Annex 1, endorsed by the respondent, in its Annex 1, my lord, lordship will find, this is the land, page 6. Page 6, my lord, that is page 7, my lord. That is
Page,
Porta number 69, page 7. It is their document, Porta number 69. It is written as Porta number 69,
no, page
page 7
of,
of the affidavit filed by the respondent number 3, National Highway. Porta number 69, my lord. Our instant claim is regarding Porta number 68 and number 18. Anyhow, my lord, they said that they have already paid, my lord.
what is the name of your husband?
My lord, Ramesh Kampre, son of Ramakanta Kampre, so-and-so college this year, post office Harangaza, Moza, Harangaza, district North Katra Hill, Porta number 59, plot number 21. My lord, now, my lord, the respondent number 4, Revenue Department, file affidavit, my lord, stating that, my lord, the land over which we have been staying now with our dwelling houses having valuable plantation like Ogoru, Sondan, Banana, Betelna, etc. They said that the land where we have been staying, that is the acquired land. So if the government decides that is our acquired land, then, my lord, for more than 2 decades, they kept silent, my lord. So nowadays, my lord, the cost of living is very high, particularly of the land, construction of a house are very high, my lord. So when we shifted from western side to eastern
Where
side,
have they stated that this is the required land?
my lord,
Where have they stated that this is the acquired land?
my lord, they have stated that this is the acquired land. Earlier, my lord, they have acquired, they paid compensation. My lord, from the same affidavit, my lord, lordship will find page 3, which I have already pointed out. They have stated that Paragraph, third paragraph, my lord, page 3, based on the available records of the respondent, number 3, the compensation was paid to the petitioner. Also, as per knowledge of the answering respondent, the petitioner has no other plot of land which has been acquired by the National Highway Authority for any project under this supervision. My lord, then also, my lord, page 8, my lord, they endorse another no objection certificate, my lord, that is President, my lord. College Disha Village, page 8, my lord. I, Sri Pandit Naidang, DP of College Disha Village, certified that Sri Ramesh Kampre of this village has possessed the land measuring 0.02 hectare. Now, land, I could not, it is in this thing, required for acquisition of additional land for construction of BG line. The land plot is belonging to him. No one has right to claim over the land as far as my best knowledge. I have no objection on acquisition of land by the railway department. It is my land, but the president college is a village. He issued no objection. When it was issued, that is also not mentioned, my lord. When it was issued, my lord.
Yes.
Then,
If
my
they
lord,
have
the authentic document may kindly be directed to produce as to when they actually acquired and how much land, in what way they have paid. So if it is more than 20 years, certainly they should pay us compensation to go another alternative plot of land. Why they keep silent for constantly long period?
Yes, Mr. Sharma.
Lordship, they have already received the compensation, Lordship.
So how have you paid them?
Lordship, that details is in the affidavit of respondent number 3, Lordship.
Respondent 3. Paragraph,
Lordship,
Lordship, we have filed the affidavit. Paragraph 5, Lordship, we have explained detail. Paragraph 5 of our affidavit.
I have already pointed out. Page 3.
The husband of the petitioner
yes.
has already received the compensation amount.
Furnish the details, how,
Yes,
how
Lordship,
much
yeah,
amount
I have annexer 1, page 6.
how?
Page 6, Lordship,
Page 6.
yes.
Where?
For giraffe and everything. Revenue, signature of revenue officer is also there.
That
But
is
the
not mentioned.
Lordship, in
This
NC
is-
Autonomous Council, they are giving like this, Lordship.
Without mentioning date.
Date,
Who is for autonomous
That-
council? Why
next,
can't you find
next,
out from your records when it has been done? And
but
what date?
next phase, date has been mentioned, Lordship. 10/4/2005,
Where?
10/4/2005,
In page number 6.
7, Lordship.
7.
It is annexure 1. This is the compensation of the Zirat also they were giving. Mango, banana, betel nut, everything, Lordship. And that land was acquired and the compensation was given to the husband of the petitioner.
On what basis are you making this statement?
So his land was acquired by the NC government, Lordship.
I know you're making a statement that his husband has been given the money from these two documents. How can you say so?
Lordship, paragraph 5, I have stated,
You have stated, but it's a statement on record, based on record.
Lordship, based on available records.
That's right. So where is that available record?
This is the record, Lordship. This is
Show
document.
us that you can make out
Paragraph
that
6 and 7, Lordship.
you
Annexure
show
1,
us from page number 6 and 7
Lordship.
that from this document you can make out that the amount has been paid to the
Yes,
husband of the petitioner.
later on, Lordship, 6,80,631.
This is under the signature of revenue officer.
Revenue officer, he will make the compensation.
Paid
He
to whom? Who has received it?
paid to the Ramesh Kemprai, Lordship, in the owner of the property, Lordship.
Where is the How have you
Account.
released the payment in cash?
No, check was given.
Where is the check number?
Check number is, we have, mentioned the check, Lordship. This number is actually is a old record. The bifurcation compensation amount was also explained in paragraph 5.
You get the check number and show us that this amount has been released by,
Check number we have mentioned, Lordship, check number 757847.
Without mentioning date, my lord, from which
That,
bank,
Lordship,
how much amount?
we have mentioned the check number. Amount
you
is
give
also
us a
mentioned.
detail from your account
Wait.
that this, when was this check encashed?
Yes,
And
That, Lordship, we have deposited the amount to the, Lordship, the NC Hills Autonomous Council. And they have issued this amount, Lordship, on, that is mentioned on 10/4/2005.
you are representing whom?
I'm in NHAI, Lordship.
Then this check amount, check number is the number of which you have, is the number by which you have deposited.
Yes, we have
NHAI.
deposited to the Autonomous Council, Lordship. And they have issued this letter, Lordship, this amount,
Yes.
the
Mr.
state
Sarma.
settlement of revenue property, they have mentioned, Lordship.
I will get the report.
তোমাকে দিছো তো,
check number was mentioned, but date was not mentioned. When it was paid, how much amount?
Yes.
To whom
We
it
have
was
How,
paid?
how are the amounts dispersed by cash,
No, Lord. From account to account,
account to account? So your details will be there.
Lordship, I will get that.
Please get it. Bring it by way of an affidavit, or at least produce the records first.
Okay, Lordship, I'll produce the record first.
You produce the records to show that this amount of 6,80,000 was transferred to the account of the petitioner or her husband. Particular.
She has not denied that she has received the amount, Lordship. She has received the amount. The husband, now she is claiming. Her
That is,
husband,
that is my lord, on the western part, not
we,
eastern
we,
part,
we,
my
we
lord.
have mentioned in our affidavit, we have not acquired the land, Lordship. We have
My lord, let
acquired,
them produce record, my lord, then my lord, lordship will.
already
decide.
husband has received the compensation, now the wife is claiming, Lordship.
No, no.
On the same land.
That is not.
How it can be, Lordship? But we have stated in our affidavit, we have not acquired their land, Lordship. If they are asking, they will get the compensation, Lordship. In the last annexure 2 also, the mention of her husband, Ramesh Kempra, is also mentioned.
He is the owner of the land, ancestral property.
Name of the affected person of NS 54E, last page, Lordship, in our affidavit. Because in her name, though no land is there. They have filed affidavit also, the
All right,
NC
my lord,
Hills.
let them produce record, my lord.
What record she put, Lord? The NC Hills has filed an
But
affidavit.
they are not inclined to produce record, my lord. Why, my lord?
Why England?
Why they
We have
are not
filed
inclined
an
to at least
affidavit.
produce record, my lord? At least to verify
Annexure
the
2,
veracity,
Lordship, her husband name is there.
at least to verify the veracity of their
And
content, my lord.
amount is also mentioned, Lordship. That is the 3D notification, Lordship. Last page. Our affidavit, annexure 2, page 11.
That is plot number 69, my lord, plot number 21. It is their own admission, my lord, plot number 69, plot number 21.
The plot number is not mentioned in this record.
There is a categorical averment in the affidavit of NHAI
Lordship,
that they have released the amount in your name, in your husband's name.
husband,
Lordship, that
You have
statement
not
we have-
denied it.
My lord, we also may have not denied, but the question is this, they said that they, by seg number, they have mentioned but not the date, my lord, when it was paid, my lord. Normally it is said that from their document, my lord, it was written as 2005, date is mentioned. That means before that they have acquired. So, my lord, proper verification has not been made.
But you have
Once-
to deny first, you check your records to find out whether this amount has been transferred to the account of the husband.
My lord, that's why, my lord, check number they have mentioned, but without date, my lord. So how could we?
Your bank will
Verify.
do the
My
verification.
lord,
You-
my husband is at present bedridden. He lost
Your-
his memory.
Your
So
husband
further-
has lost his
Yes, my
memory,
lord.
I understand,
If
but
they mention the date of,
does he still retain a bank account?
my lord, that I had to take instruction, my lord.
Find out.
And she is also illiterate, my lord. What, my lord, what I want to say, they mention about the check number. Why they did not mention the date?
Oh, that is a long.
We have
Madam,
to,
please tell us first thing that whether this check amount stated to have been mentioned in the affidavit
well, I have
has been
stated
received
in-
by the petitioner's
I have
husband.
stated in my reply, her husband, my lord, could not remember as to how much amount of money was paid to him. That's why, my lord, the check number with date, if it is given, then we have to verify, my lord. They have mentioned the check
verify-
number.
You verify from the bank. If
No,
you
my-
have an account, you verify from the bank account.
no, in which bank, my lord, they have deposited, that is also
How
not
many
known to
accounts
us.
do you have?
At least check number, check date should be given, my lord. Check number is given,
How
but date is
many,
not mentioned.
how many accounts stand in the name of the petitioner or her husband?
My lord, I have husband's name. At that moment, her
Yes, how many accounts?
that is, my lord, I cannot say at this moment,
Exactly.
huh?
So you go to the bank,
My lord, yes, my lord.
check the accounts and find out tentatively whether this amount has been received or not.
My lord, it is not possible for us as because at present he could not say anything. Let them produce the record as to when they paid the amount, my lord. We are not disputing that fact, my lord.
No,
Now
unless you dispute, we can't direct it.
now the,
Why
my
should
lord,
we
now
direct
the
it?
question is this, my lord.
They have not
After getting the western part with my dwelling houses, my lord, we have constructed on the eastern side of the land, my lord, way back more than 2 decades. They ought to have prevented
So
us
that
if
was
the
the
land
request.
actually belonged to the acquired land. Now it is more than 20 years. So as per my lord, we are entitled to right to fair compensation and transparency in land
That is what
acquisition.
they have said. They have released this amount to you. You are unable to say when you have received this amount. You are unable to say whether this amount has been transferred or not.
Yes, but that is the problem, my lord. That's why, my lord.
If that is
my
the problem,
respectful-
why should we
Yes, my
direct
lord,
them
my
to?
respectful submission before the honorable
They have
court
not
is this.
denied, lordship.
They said that they have already
You
paid.
file RTI under them, application under RTI for this information. Unless you tell us that this amount has not been transferred, not received, where is the scope to direct them to produce records in court to facilitate you to go through their records?
That is exactly.
What are you asking?
That
madam?
is correct, my lord. Now the question for argument's sake, my lord. Suppose they
You can,
paid,
you can argue only when there's a,
suppose
when-
they
when-
paid.
you can only argue in law points.
My lord,
There's a factual issue you have not disputed. Where's the scope for argument?
my lord, in my opinion, in reply, my lord, I have stated, my lord. My lord, I have stated in paragraph 5, my lord, in my opinion, in reply, my lord, I like to cite this. That with regard to the statement made in paragraph 5 of the affidavit, the deponent begs to state that on the western side of the intended four-laning national highway road, her father-in-law had a plot of land as stated by the respondent with residential houses of his family having valuable plantations. The respondent authority acquired the said plot of land by dismantling the said dwelling houses of her husband and her father-in-law and paid a small amount of money. Thereafter, the family of the deponent shifted to their another plot of homestead land situated on the eastern side of the said road and constructed residential houses on the said land. At present, the husband of the deponent is bedridden due to various diseases. He could not remember how much sum of money was paid to him. Moreover, it was a matter of about 15 or 18 years back. In order to verify the veracity of the respondent's contention, the respondent has not clearly mentioned about the date and name of the bank in the alleged check number as it appears. The reliability of the documents annexed in the affidavit are not authentic and not admitted by the deponent. As such, the allegations that asserted by the respondent in its affidavit and in the aforesaid paragraph are factually incorrect and not accepted. My lord, at present, my lord, I have been living with my ailing mother-in-law, with my husband and 2 minor children, my lord. Suppose, my lord, they have acquired the land which land over which we have been staying. It is a matter before 2005, my lord, and we have constructed on the eastern side. So if the government decides that the land over which we are staying now, it is their required land, my lord, I have no alternative than to vacate the land. And since they have admitted I have no alternative plot, so let them.
How have they issued any notice to you for vacating?
No, my lord. On 4th of May 2023, respondents meet entered into my residence and posted 4 pillars saying that land will be acquired for national highway. You vacate the land forthwith. And what they did now, my lord, during the pendency of this case, my lord, recently they again entered into my premises and started digging earth, creating a dangerous situation. My lord, it is a slightly hill area, my lord. At any moment, there will be possibility of landsliding. My lord, I filed additional affidavit, my lord, before this honorable court. And I represented the matter before the deputy commissioner, but deputy commissioner did not take any action, for which I have filed this additional affidavit, my lord, endorsing the representation submitted before the deputy commissioner. This is the
What is
additional
your
affidavit.
reply? Any, Dima Hassan?
Lordship, our reply is that we have already given the compensation amount. And
Their claim is that you are now further acquiring or have already acquired the portion
Only-
of the land where they are residing.
no, Lordship, we are not acquiring anything, Lordship, now. We have stated in our paragraph number 7, affidavit, but page number 17.
Which land have you acquired for the national highway purpose?
Patta number 68, Dag number 18.
What is the measure of land there?
Measure, hectare. Area in hectare. 0.02 hectare.
0.02 hectare.
About 2 quotas, some lesser, my lord. 1 hectare is equal to 7 gigas and something, my lord.
Bigger than 7%.
The fact that you are residing in that portion of the land,
My lord, they said that it is their required land. So we cannot override government decision. My lord, proper verification should be made. If we actually, my lord, stayed over their acquired land, that is a long back, my lord, 20 years back, my lord. Till now we have been there, my lord. When we shifted from the western side to eastern side and constructed house, they did not raise any objection, my lord. Now it is more than 20 years. So, my lord, the similarly situated persons, my lord, where land has been acquired, now they have been getting second installment of compensation, my lord. If that is so, then now we are entitled to second installment as because to purchase a plot of land and to construct a house. It is their fault,
you
my lord.
get all the particulars which you are acquiring for construction of the national highway.
Yes, my lord.
This mere statement that you are acquiring land over tag number so and so, patta number so and so, whether it is the entire land, portion of the land,
Portion of the land, Lordship.
where have you stated in your affidavit?
In our affidavit it is not there, but in any affidavit.
You are the acquiring authority. Why don't you bring it on record?
I will get that.
And also the particulars as to what amount has been paid and to which account.
A check amount.
Amount we have stated.
Third,
Let me bring some Friday, my lord.
Lordship, not
The
Friday.
petitioners, the respondents have filed their affidavit
Unnecessary obvious.
disputing the averments made by the petitioner that compensation over the land acquired for construction of national highway was not paid. So the
Oh,
National Highway Authority in their affidavit has stated that an amount of rupees 6,80,631 was deposited as compensation by the check number 757847 payable to Sri Ramesh Kemprai, the husband of the petitioner. Stop. The said amount was stated to have been released to the husband of the petitioner. Stop. The uh, 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 Dima Hasao authorities, however, has not given the particulars as to how the sale amount was released to the husband of the petitioner. Stop. Further, the writ petitioner has also claimed that the land on which they have been residing for the past 20 years have suddenly have uh, the petitioners have now been informed that this is also an acquired land and they are required to vacate the said land immediately. Stop. The respondents dispute this contention, stating that no further land is acquired. Stop. However, the pleadings on record does not reveal the clear picture of the measure of land and the area which has been acquired by the respondent authorities for construction of the National Highway project. Stop. The respondents are therefore directed to bring on record the exact measure of land and the area which has been acquired for the purposes of construction of
Area
National Highway.
dispute.
Stop. The amount stated to have been released as compensation to the husband of the petitioner. The particulars relating to the amount stated to have been released as compensation, the husband of the petitioner, should also be brought on record by way of an affidavit. Let this matter be listed again in the third week of July, by which time the affidavit is directed should be placed on record. Please speak.
July is the holiday, my lord. We can get the.
Third week.
Actually, the petitioner's name, no land is there. Her
Is
father-in-law.
claiming on her behalf of her husband.
But she has not been authorized. Obliged.
I think you are right.
Yes.
I have received one instruction last that lordship was right.
Yes. Yes,
This is the instruction, Lord.
this is exactly what was already there, nothing new. Nothing new.
They say that Lordship, my Lord, Assam agricultural land regulation and reclassification and transfer of non-agricultural purpose Act 2015. The
Hmm.
section 5 and subsection 4. My Lord, Deputy Commissioner has, my Lord, he can, my Lord, that accept it or my Lord, approve it, or he may deny it. Within 30 days, it is there. So they have mentioned in the paragraph number 3, Lord.
Do you have that copy of the act available?
Lordship,
here?
it is already been annexed, my Lord.
Your affidavit. Yeah. Towards,
I have supplied my lord the gazette notification also. Perhaps it is on record.
Well, see the affidavit of Abdul Mateen. It starts at
130.
না মোটো বেলেগ আপনার এই অনন্তরে রয়েছে
Oh,
94 203
different writ petition.
yes same or second one
First one, in the first one also there is there, my lord. Is there? In the affidavit by one Vivek Nanda Jha.
130.
Lordship may take up the first one. It starts from page, my lord, 112. Sorry, my lord, 110. 109, my lord.
Yeah.
অনন্ত আছে না
Yes, it is there.
yes my lords I have annexed my
Four or five. 4 or 5, section 4 or 5.
no 5 or 4 the 5 is 1 on 13 parent section and the subsection is at 1 on 14
You read 5.
procedure for land reclassification and reclassification cum transfer. 5.1. Any owner of agricultural land who intends to reclassify or reclassify cum transfer agricultural land for non-agricultural purposes under clause 1 and 2 of section 3 shall make an application to the deputy commissioner under whose jurisdiction the agricultural land is situated, giving full particulars of his land and justification of the proposed reclassification or reclassification cum transfer as under section 4 in such form and manners as may be prescribed. Number 2, an application under subsection 1 of this section shall be accompanied by an affidavit duly sworn in by the owner of the land to the effect that the land proposed for the reclassification or reclassification cum transfer shall be put to the permitted non-agricultural purpose within the stipulated period. The deputy commissioner shall call for a report from the circle officer concerned immediately under whose jurisdiction the agricultural land or a part thereof is situated, and after making such inquiries, including field inquiries as may be necessary, the circle officer shall submit a report to the deputy commissioner in his recommendation within 15 days from the date receipt of the order of the deputy commissioner calling for his report in such form and manner as may be prescribed. 4. The deputy commissioner shall accord in principle approval or deny approval altogether for allowing reclassification or reclassification cum transfer as the case may be within 30 days of the receipt of the recommendations of the circle officer, and while doing so shall take the opinion of a district level committee headed by himself with officials drawn from relevant district line departments as may be prescribed, or take such expert advice that may be deemed necessary for arriving at a decision. Provided that in case the total area intended to be reclassified come transferred is above 50 bighas, the deputy commissioner shall accord his in principle approval only with the prior permission of the government in the revenue department in such manner as may be prescribed. Shall I read the whole, my lord?
So in this case, there is a committee recommendation which has been overturned by the DC. And is there any appeal against these orders?
No, my lord.
Now, my lords, this issue at hand, my lords, the 3G notification is already out, and the requisite compensation has been, my lords, deposited to the Kala.
My lord, the NHI DCL.
And now, my lord, I will reply to that,
started
my lord, my lord.
arguing the
What
matter.
about-
Even
what
I have
about
not
section
started.
No, my lords,
What
last
about
on,
Section 17,
my lords,
Section 17 of the Act.
17. my lords. One appeals. Revenue, sir, within 60 days. I want to indicate the footnote.
Other portion of
There's a section.
Hmm.
Will demonstrate, my lord, that the entire proceedings will extract and inflate the proceedings, the compensation amount. My lord, section 10. Page 116.
My lord, I understand it is my writ petition. Before, my lord, I should be afforded the opportunity. My learned friend will have his turn. And even, my lord, my submission is NHI DCL is totally extraneous, my lord, so far as the act is concerned. And the deputy commissioner have a say, my lord, in the matter. I have even not started, my lord, my submission.
Hmm.
And my learned friend, my lord, is
Just pointing out.
you did not start, therefore he started.
he has not allowed me, my lord.
Why have you not started? You start
intercepted
your
me.
argument. You start your arguments. First, tell us that there is an appellate forum. Why have you not approached the appellate forum? It's a mandate of the Act.
My lord, my submission is, lordship is correct.
Hmm.
My lord, this appeal will not always, my lord.
There we know it is not an inflexible bar, but
Yeah.
what are the reasons for for not insisting on alternative remedy? Yes, Mr. Talukdar.
My lord, my lord, your lordship will kindly see, my lord, here is a case where the essential authority of the deputy commissioner has been abdicated. He has abdicated his authority and thereby he has relied on authority who is wholly extraneous, my lord, to the statute. And secondly, my lord, here is a case where there is a violation of the principles of natural justice also, my lord. What has happened pursuant to completion of the process, in principle approval was granted. And thereafter, the 3A notification which was issued, my lord, our names, my lord, was shown, my lord, land was reclassified as industrial land. And thereafter the,
My lord, I mean, someone has put, can I go and come?
Yes.
after, my lord, the reclassification process came to an end, the lands, my lord, were shown as industrial land. And to this effect, the 3A notification have been, my lord, annexed by the respondents, my lord, to the counter affidavit. Now, under the Highways Act, there is a, my lord, procedure for filing objection. If, my lord, one is aggrieved by the 3A notification, he would be afforded an opportunity to file the objection. Now, my lord, the names or the class of land having been classified as industrial land, so therefore there was no opportunity on our part or occasion on our part to, my lord, submit any objection. My lord. Now, thereafter, when the 3D notification came in, the land was reversed, showing that, my lord, it is agricultural land. Secondly, my lord, here what has happened, NHIDCL has nothing to do so far as, my lord, the reclassification process is concerned. NHIDCL may have a say in respect of the compensation, in respect of the acquisition, my lord. State legislation, my lord, confers power only on the deputy commissioner and the district level advisory committee. Therefore, my lord, the NHIDCL is totally extraneous to the particular state legislation. And the affidavit of the deputy commissioner is very much clear. Without applying his mind, he acted on the advice of the, my lord, NHIDCL. He has abdicated his authority, and without any application of mind, the impugn order, my lord, is passed.
Therefore, he should have gone in appeal before the competent
On these facts,
appellate authority.
my lord, since there is a violation of the natural justice also, my lord, there is no bar, my lord, in entertaining this petition by your lordship, my lord, because the facts are absolutely clear. There is no dispute. Here, my lord, only question of law is required to be decided.
Where is the in principle approval granted?
Yes. Take a minute. My lord, it is reflected in the impugned order itself. In the pursuance of the letter, page 80, my lord, annexure 9, letter number so-and-so, dated 2/1/24, received from the Deputy General Manager, NHIDCL, Silchar, the 19 numbers of application for reclassification of land under Nilam Bazar Circle, approved in the DLC meeting, district level committee meeting.
Page number?
Page number 80, annexure 9. It is reflected in the, my lord, impugned order itself. Held on 20/12/23 at 3:30 p.m. in the conference hall of is hereby cancelled.
No, under the provisions of the Act,
My lord.
if you come to
My lord, the records will be available with the Deputy Commissioner. That, my lord, all the proceedings, my lord, are not before me. I don't have the access to that.
5.5.1,
My lord.
sorry, 5.3,
Well.
5.4,
Well,
there is an option for granting in principle approval
Yes.
or deny approval.
no, my lord, what I'm trying to say, the DLC can deny that this, my lord,
No, it is the
requirements-
DC. The power is vested on the DC.
Yes.
Kindly come to 5.4 of the section.
That is correct, my lord. Your lordship will kindly see what I'm trying to say.
Hmm.
He has not denied, but the in principle approval, after the granting of the in principle approval, the classification has been cancelled. Had it been a case that while deciding, my lord, the applications,
Who,
it was
who
cancelled.
has to grant an in-principle approval?
Correct, my lord, assuming that the deputy commissioner has the power. I am not saying, my lord, he cannot cancel. What I am trying to say, my lord, he has to apply his mind. He cannot abdicate his power. Apparently, in the present case, he has acted on the advice of the, my lord, the NHIDCL. And your lordship is aware, there are so many judgments, my lord, that the statutory authority has to exercise, my lord, his own power. He has to apply his mind. He cannot act
No, on what basis are you saying that there is no application of mind?
on the basis of the impugn order.
Have you been communicated with the in-principle approval?
My lord,
Are you aware of whether there is an in-principle approval?
my lord will kindly see, my lord, from the impugn order itself, it is apparent that he has acted on the advice of the NHIDCL. Nothing more is necessary, my lord, in my respectful submission. And the affidavits, my lord, which are filed by the deputy commissioner, he makes it very clear that I have acted on the advice of the NHIDCL. Now, the present, my lord, instruction which has been placed, I have the opportunity to go through it, my lord. The deputy commissioner says that yes, as per the advice of the NHIDCL, the order has been passed. Hello, let this instruction be put on record.
For what purpose?
That,
You
my lord,
are already you are already before this court saying that there is no application of mind.
correct. Because on the last occasion, your lordship had directed.
We had
that-
directed.
Yes,
they had
what are the
given us a
grounds on
report.
which, my lord, the cancellation was done?
Is there any in-principle approval? Huh?
On the last occasion, your lordship said that if he does not file the affidavit, let him produce the record. The record is also not produced. The record will reveal, my lord.
See, their grievance is that what is that? What committee is that? What is that committee? District
Land Advisory Committee.
Land Advisory. So they have approved. Now, was there in terms of Section 5? This is the procedure laid down, isn't it? Procedure for grant or rejection is as per Section 5. So how this procedure was followed by the authority, that we want to see. If you have not followed the procedure, then you have to explain why. There is a requirement of the DC to call for a report from the circle officer. Where is the report of the circle officer? Then
My lord, lordship wanted to peruse, my lord, those reports. That is why on the last occasion, lordship said that file an affidavit or you produce the record, whether the procedure was followed or not. Now, if the instruction does not contain the necessary part, then my lord, he has to place the record. If, my lord, there is no irregularity in the process, the reclassification, my lord, which has culminated, that should be allowed to sustain, my lord.
Do you have the records? If the government is of the view that additional burden is not warranted,
No.
what is wrong about it? As an agricultural land, you'll get some compensation. But if it is reclassified, the amount of compensation is far higher.
Lordship is correct. My lord, my submission is on a very limited area.
Hmm.
The deputy commissioner is a statutory authority.
Correct.
Had the order been passed on the grounds, number one, that the reclassification process is not permissible on such and such grounds, or here there is a my lord, attempt to have my lord excessive compensation. Had my lord the order been my lord based on such grounds, my lord, then yes, my lord. But here is a case your lordship will see. Deputy commissioner says, who is the authority, says NHIDCL says, so therefore cancel it. The question is, my lord, whether it is permissible under the facts, my lord. He does not say that the process is irregular. The land cannot be reclassified. That is not the case, my lord. And all the, my lord, reports, my lord, have been considered. And the committee has, my lord, granted the, my lord, in principle approval. After the culmination of the process, my lord, Deputy Commissioner has cancelled merely on the basis of a letter issued by the NHIDCL.
But the law says that they are within their rights to take that consideration, that aspect into consideration also. The fact that there will be additional burden on the exchequer is also a valid consideration.
There is a consideration, my lord,
Correct.
but that is not reflected, my lord. Deputy Commissioner himself, my lord, has not decided that it will be, my lord, a burden on the exchequer or this is not permissible on the facts. The statutory authority has not decided.
Did you actually start in the industry of the land?
There is there. We have, my lord, annexed documents, my lord. There is industry
You've
there.
already started. You have already started.
Yes, photographs are there, my lord.
No. The land was not reclassified.
Not reclassified.
Prior to that, you started your industry on agricultural land.
Preliminary stage, my lord. Preliminary.
So what is this preliminary? Have you started your industry or you have
The
not
activity
started?
was started because photographs are, we have annexed, my lord, photographs.
But then the reclassification was not done. Who gave you permission to start
That is
industry on
correct.
agricultural
That is
land?
correct, my lord. My lord, lordship will see from the, my lord, what was the actually the decision. On what basis, my lord, the impugn order has been passed.
There is a judgment of the apex court, not one, several judgments of the apex court, that this is one of the considerations to be taken note of. Whether by on his own or suggested by another government authority, merely because that particular consideration did not fall within the decision. Somebody suggested, he examined, he found, yes, this is the ground.
The reclassification process is only barred, my lord, under the law when the, my lord, 3A notification has been issued. Otherwise, legally, my lord, there is no bar. And the 3A notification was issued much later. It was issued only on, my lord, 18/1/24. And the process, my lord, under the state legislation,
No, if your, see, if your grievance is that because you have taken all steps to start your industry and there has been an approval to that project given by the land acquisition, what is that committee?
land advisory committee.
Land advisory committee. And while you were in the process, the 3A notification, etc., came to be published. That is not your case.
That is my case, my lord.
You did not start the industry. You could not have started the industry
No, my
because
lord.
it is on agricultural land. You are taking steps to start an industry, but prior to that, it has to be reclassified.
Yes.
Have you stated that in your affidavit? There are 5 of your affidavit says no comment. Yes.
But now the DD notification is out.
You are for national highway.
National Highway. My lord, we are not the experienced party because, my lord, what has happened in the motivation election. If the petitioner succeeds, my lord, the amount, my lord, of compensation, definitely, my lord, the land is going under highways, my lord, and if the reclassification is allowed, my lord, it goes to it is to the tune of.
But that way, that argument you can apply to any land which may or may not be acquired.
It has been acquired because, my lord, before the 3 my lord, there is a stakeholders meeting. Only when they came to know that this land is acquired. My lord, kindly come to that section 10 of the, my lord, the act. My lord.
Yes.
Section 10 is mandatory. Mandatory establishment of the approved non-agricultural activity within 3 years. My lord. Suppose, my lord, NHIDC is wrong, everybody is wrong. My lord, whether this exercise of applying for reclassification.
You read section 10, tell us.
Where and no objections, NOC for reclassification accorded by the Deputy Commissioner under subsection 7 of the section 5. It shall be mandatory for the owner to establish the approved non-agricultural activity within a period of 3 years from the date of reclassification on the said land in the land records of where such that no objections, NOC is accorded for reclassification come transfer. It shall be mandatory for the transferee to establish the approved non-agricultural activity within a period of 3 years from the date of registration of deed of transfer. Provided that the Deputy Commissioner, for reasons beyond the control of the owner or the transferee, may extend the aforesaid period of 3 years for establishing the non-agricultural activity by another 2 years, and the cumulative period for establishing the approved non-agricultural activity in no case shall exceed a maximum period of 5 years, including the initial fee period. 2 minor. If the owner or the transferee fails to establish an approved non-agricultural activity within the period as mentioned in subsection 1 of this section, the Deputy Commissioner, on expiry of the said period, including the extended period, if any, shall impose a penalty upon the owner or the transferee at a rate equal to 10 times the reclassification premium that was paid on the land by the owner or transferee before issuing reclassification or reclassification cum transfer, as the case may be, in accordance with section 6, and shall deny further transfer of the said land for a 5 years starting from the date of expiry of the approved fee of 5 years period accorded on section 1 of the section. Provided that the government in the revenue department may, for reasons beyond the control of the owner or the transfer, relax the aforesaid ban on the further transfer from 5 years to 2 years in appropriate case. 3, nothing in this section shall restrict the right of the parents of final to recover any unpaid monies from any.
Where is the land advisory committee report?
My lord, that is not part of the record, the entire proceedings. And your lordship wanted, my lord, the deputy commissioner to place it to see whether there was any irregularity. My lord, I suggest, my lord, that they let the records be placed, and I will also, my lord, make my submission. Lordship will hear both the sides, my lord, and dispose it of.
That is what we were doing for
Yes.
the past half an hour or so.
One thing I can consider up to
Yes.
that extent that he had accorded approval. But before cancelling this, he should have he should have given notice.
You produce it on Tuesday. We are passing orders. We are just giving you one opportunity to produce whatever relevant records the TC wants, including land acquisition.
Well,
I'm sorry, land advisory committee report.
Well.
Matter be listed again on 25th. Government will produce the relevant reports in respect of the order dated so and so. What is that order dated? 4-1.
my lord,
4-1-20,
the impugn order, my lord,
4-1-24,
my lord. 8/1/2024, my lord.
8-1-20, leading to the order of the TC, Karimganj, 8-1-2024.
Well, obliged.
Uh, The court will attempt to dispose of the matter on the next date fixed.
Obliged.
Mr. Hendick appears for the government. Mr. Gogoi for NHITCL. MSG Hazarika for respondent 1, MSG Bora for respondent 4.
Obliged.
Yes.
May I please do? My lord, the issue, my lord, before the court is, my lord, we have challenged the order passed by the, my lord, arbitral tribunal, whereby, my lord, tribunal had proceeded, my lord, beyond the scope of the arbitration agreement, my lord. And the matter was referred, my lord, if I may refer the facts of the case, my lord, pursuant to an application under section 11, my lord, the court under section 11 has, my lord, directed to this arbitral tribunal to decide on the arbitrability of the dispute. And my lord, while deciding on the issue of arbitrability, the tribunal held a dispute to be arbitrable. My lord, that order is under challenge, my lord. My lord, the basic ground for challenge is that, my lord, the decision of the arbitral tribunal is prima facie contrary to the terms of the contract, my lord, on two grounds, my lord. Firstly, that the contract agreement, my lord, clearly specifies a clause, my lord, which says that more than 20% of the dispute of the contract value would not be arbitrable. And secondly, my lord, no arbitration can be claimed before the completion of the work. These are the two, my lord, basic clauses in the agreement, which was, my lord, the plain reading of the clause that was ignored by the tribunal, and the tribunal is proceeding to examine the matter for arbitration. Now, my lord, I will take, my lord, to the termination letters, my lord, in respect of two contracts. My lord, two contracts are in question here, page 20 and page 21.
Page
20, my lord, is
20.
this termination letter dated, my lord, 28/12/2020.
Yes.
My lord, this is the letter, my lord, by which the contract, one of the contract, my lord, that was terminated. by the railways. Thereafter, my lord, another page, the next page, my lord, is the termination letter dated 19/1/2021. My lord will mark the two dates, my lord. One is dated 28/12/2020 and another is 19/1/2021. That is the main cause of action, my lord, pursuant to which an arbitration would have been raised by the claimant, but that was not so. Now, my lord will peruse the arbitration notice, my lord, that is at page 30. My lord will see the date, my lord, page 30. That is dated 19/8/2020, even prior to the termination of the contract. And my lord, this application was under 64(1), and thereafter, my lord, another application was preferred at page 39 that the claimant, my lord, refers to as a claim for, my lord, second arbitration under the additional conditions of contract, my lord, page 39. That is also, my lord, dated 17/12/2020. So, my lord, even before the cause of action arose, my lord, the matter was referred to arbitration, and the contract clause, my lord, specifically bars that, my lord, before the completion of the work, no arbitration can be claimed. Here, my lord, work was not completed. Thereafter, my lord, which led to the termination of the contract. And, my lord, even prior to the termination of the contract, the matter was referred to arbitration. My lord, my contention, my lord, is that, my lord, in respect of the two clauses, my lord, which prima facie bars the matter to be referred to arbitration, the matter was, my lord, proceeded ahead with the arbitration, my lord, and which now, my lord, we have challenged. My lord, the primary issue on the last occasion, my lord, which was raised regarding the maintainability, my lord, I would like to address on that, my lord. First, whether the petition is maintainable under Article 227 or not. Regarding that, my lord, I would just like to submit that, my lord, this issue which is arisen before the court, my lord, it is arisen out of the, my lord, order passed under Section 11, by which, my lord, the court has directed the tribunal to decide on the arbitrability of the issue. There was no question to decide on the jurisdiction of the tribunal. My lord, the issue of jurisdiction of the tribunal is dealt with by Section 16. There was no petition filed by us, my lord, challenging the competence of the arbitral tribunal, which is provided under, my lord, Section 16 of the Act, to rule on its own jurisdiction. Therefore, and secondly, my lord, the Article 227, my lord, it's a constitutional provision. And the power of superintendence, my lord, would always be there, my lord, in cases where, my lord, there is a patent lack of inherent jurisdiction. My lord, to support my contention, my lord, I am relying on two judgments.
So first tell us,
My lord.
before the tribunal, there's a provision to file an application to decide the jurisdiction.
There is a
16.
provision.
That you have not done.
That was not required also, my lord, because the Section 11 code, my lord,
was there a direction? Where is the order under appointment of the arbitrator under 11.6?
my
Where
lord,
is that order? Page 50.
Page 50, my lord. The relevant paragraph, my lord, it starts from, my lord, paragraph 54. If I may read from, my lord, a little bit earlier. Because ordinarily, my lord, this is a matter, my lord, which would have been decided at a pre-referral stage itself, my lord, because there is similar judgment of our High Court, my lord, on the ground of 20% claim, my lord, the court has rejected the section 11 petition itself. But my lord, if I read paragraph 54, my lord, why the need arose to refer the matter to the learned arbitrator, my lord, starts from page 73, paragraph 54.
Yes, please read.
My lord. What this court would like to emphasize is that as per the terms of the contract between the parties, either of these two views is possible. If that is so, this court is of opinion that it would be more appropriate for the arbitral tribunal, not this court, to decide as to whether the claims made by the contractor can be considered item-wise or by taking into account the total value of the claim for the purpose of ascertaining whether it is equal to or more than 20%, which will determine the arbitrability of the claim. The present trend in the arbitration law is that the involvement of court has to be minimal at the referral stage under Section 11 of the Arbitration and Conciliation Act 96. And where there is any doubt or contentious issues, normally it ought to be referred to the arbitral tribunal to decide, unless arbitration is plainly and indisputably barred by law or found not maintainable or exercise time barred, in which case law does not contemplate referring to arbitration which are not arbitrable. As the scope of the role of the court, especially at the stage of consideration of application in the Section 11 of the Arbitration Act 1996 and about arbitrability, it has been succinctly put in Vidya Drolia Supra in the following words. Discussion under the heading Who decides arbitrability can be crystallized as under ratio of the decision in Patel Engineering Limited on the scope of judicial review by the court while deciding an application under Section 8 or 11 of the Arbitration Act post amendments by Act 3 of 2016 and even the post amendments by 33 2019 is no longer applicable. Scope of judicial review and jurisdiction of the court under Section 8 and 11 of the Arbitration Act is identical but extremely limited and restricted. The general rule and principle in view of the legislative mandate clear from Act 3 of 2016 and 33 of 2019 and the principle of severability and competence. Competence is that the arbitral tribunal is the preferred first authority to determine and decide all questions on non-arbitrability. The court has been conferred power of second look on aspects of non-arbitrability post-award in terms of subclause 1 to 4 of Section 34(2)(a) or subclause 1 of Section 34(2)(b) of the Arbitration Act. Rarely as a demurrer, the court may interfere at the stage Section 8 or Section 11 stage when it is manifestly or exercise certain that the arbitration agreement is non-existent, invalid, or the disputes are non-arbitrable, though the nature and the facet of non-arbitrability would to some extent determine the level and nature of judicial scrutiny. The restricted and limited review is to check and protect parties from being forced to arbitrate when the matter is demonstrably non-arbitrable and to cut off the dead wood. The court by default would refer the matter when contentions relating to non-arbitrability are plainly arguable, when consideration in summary proceedings would be insufficient and inconclusive, when the facts are contested, when the party opposing arbitration adopts delaying tactics or impairs conduct of arbitration proceeding. This is not the stage for the court to enter into a mini trial or elaborate review so as to usurp the jurisdiction of the arbitral tribunal, but to affirm and uphold integrity and efficacy of arbitration as an alternative dispute resolution mechanism. Thus, minimal intervention by the court at the referral stage is the norm, in spite of the power of the court to decide on arbitrability. In the case of Indian Oil Corporation Supra, which the respondent's authority relied on, the Honorable Supreme Court emphasized that the court can decide on arbitrability if only if the facts are very clear and glaring. In the present case, as discussed above, the facts are not clear and glaring as to warrant intervention by this court at this referral stage. In the present view, in view of the wrong mentioning of the arbitration clauses as also admitted by the railway authorities in their para 12 of the affidavit in opposition, as quoted above, certainly a contentious issue has arisen about the arbitrability of the dispute, apart from plausible view that the claims can be raised item-wise and claims need not be clubbed together for the purpose of deciding whether the claims is less or more than 20% of the value of the work. Thus, as to whether the claim can be split to decide arbitrability as contended by the petitioners in all these petitions is a contentious issue, which in the opinion of the court should be left to be decided by the arbitrator. The plea taken by the contractor that the claim can be individually considered and split and not necessarily clubbed together is also a very plausible interpretation of contract, which can be best considered by the arbitral tribunal. Accordingly, for the reason discussed above, this court is of the view that the present petition filed under Section 11 of the Arbitration Constitution Act are maintainable. Accordingly, this court proceeds to appoint Honorable Mrs. Justice Anima Hazarika, retired Justice High Court, as the sole arbitrator to decide the disputes, including the issue of arbitrability, in respect of arbitration petition, subject to her willingness and disclosure. So therefore, my lord, the issue of arbitrability was, my lord, directed to be decided before, my lord, going into the merits of the case. And accordingly, my lord, the arguments were, my lord, made there, and my lord, the learned tribunal, my lord, came with a conclusion that the dispute is arbitrable. But my lord, when we prima facie refer to the, my lord, the clauses which I have, my lord, just now stated, there is an express bar, my lord, in the, so that the matter cannot be referred to arbitration. The first bar, my lord, is that the section 20% of the contract, if the value is more than 20% of the contract, my lord, the dispute cannot be referred to arbitration. And my lord, on that issue, my lord, already there is a judgment of our court, my lord, which I have on the last occasion referred, my lord, that is 2024 STC online, my lord.
ATW.
80W. My lord, that is already holding the field wherein, my lord, at a pre-arbitral stage itself, my lord, the arbitration petition in the section 11 itself was rejected. At that point of time, my lord, the judgment was not in force, my lord. Subsequent to this impugn order, my lord, this judgment came. And the second, my lord.
No, what are the facts involved here in this matter?
Not in 80W?
80W?
Yes, 80W says, my lord, same railway contract, my lord, the same nature of clause, the same nature of contract that was in question, my lord. And the
So what are the clauses in 80W?
My lord, the clauses in 80W, my lord, those were, my lord, it was 64.7, my lord. My lord, if I may refer to the judgment, my lord, paragraph 11, the clauses are referred. The language is the same, my lord. The clauses numbers are different. There it was, my lord, 10.0, 10.1.
Yes.
Similar clauses were there, my lord. And the second clause is, my lord, before the completion of the contract, my lord, there cannot be any arbitration. Here, apparently, my lord, as I pointed out initially itself, my lord, that the termination of the contract took, my lord, subsequent to the arbitration notices which were sent by the claimant, my lord. And in fact, those two termination notices, my lord, they are not under challenge also in the claim petition, the claim before the London Arbitral Tribunal. Because, my lord, those termination of contract, my lord, has led to the forfeiture of the bank guarantee and the, my lord, the security deposit. So, my lord, these are the two basic, my lord, express bars in the terms of the contract, my lord, which bars the arbitration.
What was the finding in the judgment?
My lord, the findings of the London Tribunal.
No, in this judgment, 80W.
My lord. And the findings, my lord, are at page paragraph 20 and 21, my lord. 2021 is the reasoning, my lord, wherein the Honorable Court has relied on the judgments passed by the Delhi High Court on a similar issue. And, my lord, paragraph 21 also, my lord, that is Globe India Enterprise. My lord, holding that, my lord, that when the aggregate value of the claim exceeds,
In ATW,
my lord,
it was a petition on the 11/6
yes, my
for
lord,
appointment.
yes, my lord,
Court came to a finding that in the facts and circumstances,
my lord,
where a dispute is not arbitrable.
not arbitrable,
And therefore,
party,
no
yes.
arbitrator was appointed.
No arbitrator was
In
appointed,
your case,
my lord,
in a petition on the 11/6, notwithstanding the concerns raised by the court,
yes,
matter was referred to the arbitrator to decide on this issue,
yes, my lord,
which has been decided. Now, against that, you have come before the court.
yes, my lord. But the
This is not,
principal,
this present proceeding is not a proceeding under 11/6.
yes,
You are challenging the order of the arbitral tribunal.
the only difference is that the principle would apply, my lord, because my lord, under ATW, my lord, at the pre-referral stage, my lord, the court has dismissed the petition. And in this case, my lord, the matter has been referred to the tribunal to decide on the arbitrability.
So therefore,
But my lord, the
you show us
principle,
the law against which you can come come to this court against an order passed by the tribunal
yes, my lord,
holding that the dispute is or is not arbitrable.
yes. Well, that we can come under 227, my lord. I have given two judgments I am relying upon, my lord. One is, my lord, Deep Industries Limited versus ONGC, because, my lord, there is no remedy under the Act. So when there is no remedy under the Act, my lord, the extraordinary power under 227 can be invoked. Deep Industries, here, my lord, I would refer to paragraph 16 and 17.
Yes.
My lord, paragraph 16 and 70 of the judgment, my lord, I am relying upon to support the contention whether 227 would be applicable, my lord. Paragraph 16 and 17 of, my lord, the judgment, my lord, has judgment, my lord.
You read it.
My lord, paragraph 16, I am reading, my lord. Paragraph 16. May I read?
Yes, please.
My lord, may I read paragraph?
Yes.
Most significant of all is the non-obstante clause contained in section 5, which states that notwithstanding anything contained in any other law, in matters that arise under Part 1 of the Arbitration Act, no judicial authority shall intervene except where so provided in this part. Section 37 grants a constricted right of first appeal against certain judgments and orders and no others. Further, the statutory mandate also provides for one bite at the cherry and interdicts a second appeal being filed. Now, this being a case, there is no doubt whatsoever that if a petitions were to be filed under Article 227, 226, 227 of the Constitution against orders passed in appeal under Section 37, the entire arbitral process would be derailed and would not come to fruition for many years. At the same time, we cannot forget that Article 227 is a constitutional provision which remains untouched by the non-obstante clause of section 5 of the Act. In these circumstances, what is important to note is that though petitions can be filed under Article 227 against judgments allowing or dismissing first appeals under Section 37 of the Act, yet the High Court would be extremely circumspect in interfering with the same, taking in account the statutory policies as enumerated by us herein above, so that the interference is restricted to the orders that are passed which are patently lacking in inherent jurisdiction. My lord, the judgment permits, my lord, that 227 where there is an inherent lack of jurisdiction, my lord. And the two clauses which I have just pointed out, my lord, that categorically, my lord, bars the jurisdiction of the tribunal. And the another judgment, my lord, is Bhaven Construction, my lord, which has taken note of these deep industries, my lord. Subsequently, this is 2022 1 SCC 75, my lord, paragraph 19.
Yes.
Paragraph 19, my lord, the Honorable Supreme Court has quoted that judgment, my lord. In this context, we may observe deep industries in versus ONGC, wherein interplay of section 5 of the Arbitration Act and Article 227 of the Constitution was analyzed. I'm sorry, my lord, may I refer to paragraph 11 also? Because the issue was directly, my lord, pointed out, my lord. Paragraph 11, having heard both the parties and perusing the materials available on record, the question which needs to be answered is whether the arbitral process could be interfered under Article 227, 226, 227 of the Constitution of India, and under what circumstance. This was answered in positive, my lord, in this, my lord, 2022 Bhaven Construction, and my lord, which has taken note of the earlier decision.
Refer to the relevant
My
paragraph.
lord. So paragraph 11 was the issue, and relevant paragraph, my lord, paragraph 19. Wherein, my lord,
Please read.
in this context, we may observe deep industries versus ONGC, wherein interplay of section 5 of the Arbitration Act and Article 227 of the Constitution was analyzed as under. Most significant of all is the non-obstante clause contained in section 5, which states that notwithstanding anything contained in any other law and matters that arise under Part 1 of the Arbitration Act, no judicial authority shall intervene except where so provided in this part. Section 37 grants a constricted right of first appeal against certain judgments and orders and no others. Further, the statutory mandate also provides for one bite at cherry and interdicts a second appeal being filed. This being the case, there is no doubt whatsoever that if petitions were to be filed under Article 226, 227 of the Constitution against orders passed in appeals under Section 37, the entire arbitral process would be derailed and would not come to fruition for many years. At the same time, we cannot forget that Article 227 is a constitutional provision which remains untouched by the non-obstante clause of Section 5 of the Act. In these circumstances, what is important to note is that though petitions can be filed under Article 227 against judgments allowing or dismissing first appeal under Section 37 of the Act, yet the High Court would be extremely circumspect in interfering with the same, taking into account the statutory policy as enumerated by us herein above, so that the interference is restricted to the orders that are passed, which are patently lacking in inherent jurisdiction.
Then 20.
In the instant case, respondent number 1 has not been able to show exceptional circumstance or bad faith on the part of the appellant to invoke the remedy under Article 227 of the Constitution. No doubt the ambit of Article 227 is broad and pervasive. However, the High Court should not have used its inherent power to interject the arbitral process at this stage. It is brought to our notice that the subsequent to the impugned order of the sole arbitrator, a final award was rendered by him on merits, which is challenged by the respondent number 1 in a separate Section 34 application, which is pending. So, my lord, these two judgments, my lord.
22. There are 22.
My lord. the High Court did not appreciate the limitations under Article 226 and 227 of the Constitution and reasoned that the appellants had undertaking to appoint an arbitrator unilaterally, thereby rendering respondent number 1 remediless. However, a plain reading of the arbitration agreement points to the fact that the appellant herein had actually acted in accordance with the procedure laid down without any malafide. So, my lord, these
So
judgments,
ultimately, what was held?
Hmm.
What was held in the
finally paragraph 27, my lord, 26 and 27. Now, it must be noted that Section 16 of the Arbitration Act necessarily mandates that the issue of jurisdiction must be dealt first by the tribunal before the court examines the same under Section 34. Respondent number 1 is therefore not left remediless and has statutorily been provided a chance of appeal. And my lord, lastly, in paragraph 27, it was held that in view of the above reasoning, we have the considered opinion that the High Court erred in utilizing its discretionary power available under 226 and 227 of the Constitution hearing. Thus, the appeal is allowed into an order of the High Court is satisfied. Therefore, my lord, the court in this judgment, my lord, held that the application is maintainable, my lord, subject to a limited scope, my lord, unless the order is patently lacking inherent jurisdiction.
Yes.
And my lord, moreover, this was a petition under Section 16, my lord. Here, my lord, we have not filed any petition under Section 16 challenging the jurisdiction of the tribunal, because, my lord, the issue of habitability of a dispute and jurisdiction of the tribunal, there are two different issues. If the tribunal, my lord, holds that it has jurisdiction under Section 16, my lord, definitely we have no remedy. We have to wait till the award, and, my lord, we can challenge it only once the award is passed. But here, my lord, when prima facie the agreement, the clause, the arbitration clause, my lord, not only the contract agreement, my lord, the arbitration clause
But
itself.
did you raise the question of jurisdiction before the tribunal?
Yes, my lord. We have filed our written objection. Therein, we have categorically raised both the points. And in fact, my lord, we have filed the, my lord, once when the arbitration notices were given, my lord, we have replied to the arbitration notice also, taking all those objections, my lord. That is at page 38, my lord.
All right, then.
My lord, these are the, my lord, so, my lord, the dispute is maintainable, my lord, and also, my lord, with regard to the interpretation of the arbitration clause, my lord, I would just like to point out, my lord, how an arbitration clause in a contract should be interpreted. My lord, I am relying on the judgment of the Delhi High Court reported in 2022 STC Online 3288. My lord, that is Panasonic India Private Limited.
It's not a part of your compilation.
It is there, my lord.
Yes.
It is there, my lord. My lord, paragraph 16, if I may read, my lord.
Para 16.
Paragraph 16.
Yes.
My lord, it reads as follows. My lord, the interpretation of an arbitration clause, as indeed of all contractual provisions, must be predicated upon a construction of the contract as a whole, and no particular word or phrase should be unduly emphasized to negate the clause of its true meaning. The use of the word can, which normally signifies an option, as opposed to the word shall, which is mandatory in nature, is not determinative of the present case. This is because the word can is juxtaposed with the words either party, signifying the option of either Panasonic or Shah Aircon to refer disputes to arbitration. If either of the parties can exercise such an option by referring the disputes under the agreement to arbitration, it is for all practical purposes binding upon the other party as well. The remainder of the clause, insofar as it refers to the venue of arbitration, the language of arbitration, the applicability of the act, the requirement to give reasons, and the procedure for appointment of an arbitrator by reference to court also supports the view that the parties intended a mandatory reference to arbitration and incorporated the ancillary provisions into the agreement for this purpose only. Clause 24 of the agreement tenders this position in as much it covers exclusive jurisdiction on this court in case of dispute with special reference to arbitration proceedings for appointment of the arbitrator. So, my lord, the court has held that, my lord, the plain meaning should be given and one interpretation should not render the other part infructuous. My lord, here when we read the contract clause, my lord, it is categorically stated in the agreement, my lord, if I may take, my lord, to the relevant portion of the contract. To page 45. Page 45 at the bottom, clause 64.7. And my lord, I am reading clause 47, my lord, in the bottom, which says, my lord, that the provisions of clauses 63 and 64 to the general conditions of contract will be applicable only for settlement of claims or disputes between the parties for values less than or equal to 20% of the value of the contract. And when the claim of disputes are of value more than 20% of the value of contract, the provisions of 63 and 64 and other relevant clauses of the GCC will not be applicable and arbitration will not be a remedy for settlement of such disputes. Thereafter, clause 48 says, my lord, the contractor shall not be entitled to ask for reference to arbitration before the completion of the work assigned to him under the contract. The contractor shall seek reference to arbitration to settle disputes only once within the ambit of 16.2 above. So therefore, my lord, when we read the clause, it cannot, my lord, reject the other clauses, my lord. Here, my lord, while learned tribunal, while adjudicating on the issue of arbitrability, my lord, has held that the rejection by the railways on the ground of 20% is valid. That was, my lord, held to be valid, my lord, page 143, 134. My lord, we take page 134. The findings of the London Tribunal, my lord, while adjudicating on the issue of arbitrability,
No, you have referred to clauses 47 and 48.
48, my lord.
Now, where are the clauses 63, 64?
Yes. 16.3, 16.4, my lord, is referred to in the, my lord, the judgment itself. The goes page 120, my lord. Page 120. 120. But the London Tribunal has, my lord.
No, in the contract agreement, where are the clauses 63, 64?
My lord, I have, on the last occasion, my lord, I have given the copy of the contract agreement, my lord. But the contents of 16.23, my lord, that is quoted in the.
Is it available at page 43?
No, my lord, it is not there.
43 of the writ petition?
Yeah, it is not there, my lord. That is part of, my lord, clause 45, my lord, that is the arbitration clause. 16.1, 2 and 3, my lord, that is in the contract agreement, my lord, that is referred to at page 120. My lord, the Honorable Tribunal has quoted that paragraph, my lord.
So you have referred to clauses
47,
47, 48.
my lord.
What is the page number?
That is, my lord, 45 and 46.
45 and 46. Now, in the same bunch, if you come to page number 43,
yes, my lord,
there is a clause 63.
Yes, my lord.
Is it the clause that you are referring to?
No, my lord. 63 is the arbitration clause, my lord.
So, clause 47 and 48 refers to 63 and 64. Which clause 63 and 64?
Yes. Lord, I was thinking about, my lord, paragraph 48. Sorry, my lord. So, paragraph 47, that's clause 63, 64 is there, my lord. I'm sorry, my lord, I thought my lord is quoting paragraph 48 and asking about 16.1 and 16.2. Paragraph 47, my lord, that is the main arbitration clause. 63 and 64, my lord, that is the main arbitration clause. If my lord will take page, my lord, the 41, my lord, the heading which starts, my lord, page 41, 45.0, settlement of disputes, Indian Railway arbitration rules, my lord. 45.1, my lord, clearly says arbitration and settlement of disputes shall be governed by clauses 63 and 64. That very clearly says, my lord, and the clauses which I have read, 48 and 49, my lord, those are additional clauses, my lord, which have to be read in continuation to 47, 48 and 49.
Where is 16, clause 16?
Clause 16, my lord, that is in the contract agreement, my lord, on the last occasion I have.
Yes, I think we have it. Program and completion period.
Program and completion period.
Yeah.
But if you read clause 16, my lord, in fact, it has no relation with the, my lord, the terms of the contract, my lord. But even presuming that to be correct, my lord, the clause 47, that cannot be ignored, my lord, which bars 20%, and also the fact that there can be no arbitration before the completion of the work assigned.
Yes.
My lord, will see, my lord, the learned tribunal has already rejected, allowed the prayer of the respondents, my lord. Paragraph 134, my lord will see the last 3 lines of the paragraph. Thus, this tribunal hold that the claimant does not have any right to demand for by invoking clause 64.11 of the GCC. Paragraph 134, page 134, my lord.
Yes.
So therefore, my lord, the initial application for initial petition, my lord, initial application praying for arbitration under 64.11 was rejected by the, my lord, railways on the ground of 20%, which was upheld by the tribunal, saying that, my lord, the claimant does not have any right to demand for arbitration by invoking 64.1.1. Now, my lord, the error which has crept in, my lord, is that the tribunal, on while deciding on the issue, has, my lord, taken clause 47 and 48 to be the additional special conditions of contract, and said that, my lord, there can be an arbitration under that clause. Whereas, my lord, in a particular single contract, my lord, there cannot be two arbitration clauses, my lord. As I have relied on the judgment, my lord, the contract has to be read as a whole, and one interpretation of one clause, my lord, will not render the other part, my lord, redundant. So, my lord, once the prayer under 64.1 was already rejected by the tribunal, my lord, the tribunal went ahead and, my lord, decided that no, under another clause, my lord, the matter can be referred to arbitration, which is not permissible, my lord, because that clause does not provide for arbitration. It has to be read together with 47, 48, and 63 and 64. It cannot be read in separation. And further, my lord, I would be relying on 2 more judgments, my lord, regarding the scope as to how the arbitration agreement should be interpreted. That is, my lord, 2018-7 SCC 607, paragraph 10 and 12. Union in
We'll come back at two.
United India.
We'll come back at,
My lord.
we'll come back at two.
I know. I'm not troubling your lordship judicial this. It will go on. I'm just mentioning it for the.
All right. In case we go beyond your timings, you instruct your.
Yes. I'm here.
Yes.
My lord, I was on the point that, my lord, so far as the tribunal's decision, my lord, tribunal has decided in two parts, my lord. In the first part, my lord, the tribunal has come to a conclusion that the initial application for requesting for arbitration was rejected by the authorities, and that rejection order on the ground of 20% was, my lord, upheld by the tribunal while deciding the dispute on the arbitrability. My lord, the tribunal in its judgment has, my lord, categorically stated that the rejection by the railways of the application for requesting for appointment of arbitration, which was rejected on the ground of 20%, my lord, bar, which is there in the contract agreement, that is held to be valid. However, my lord, the London Tribunal went ahead and interpreted, my lord, the clause 48 and 49, which I have read, and termed it to be, my lord, additional special conditions of contract. My lord, in the impugn order, everywhere it is referred to as additional special conditions of contract, which is not so. These are part of one arbitration clause, and both cannot be interpreted in a vacuum. That one part, the application for arbitration is rejected, saying it is not arbitrable, and the other part, my lord, interpreting clause 48 and 49, saying that, my lord, the dispute is arbitrable under another clause, which is within clause 63 and 64, saying that, my lord, 48 and 49, hence dispute would be arbitrable. My lord, that bar of 20%, already, my lord, it is decided in favor of the railways, saying that no, it is not arbitrable. And on the second part, my lord, that is where our grievance is, my lord, that there cannot be two clauses in arbitration, and further, my lord, one clause cannot altogether ignore the other clause. Even presuming, my lord, that the dispute is arbitrable, that bar of 20% would be there.
No.
And secondly, my lord,
You may have a right, you may have a grievance, but why not take it up in an appeal as and when the arbitration is
because, my lord,
completed?
because, my lord, prima facie, my
What
lord,
is it that
yes.
requires the intervention of this court?
Yes.
This state?
because prima facie, my lord, the tribunal is proceeding on the basis of a clause which is not an arbitration clause. My lord, if the tribunal went ahead and decide on the basis of a clause
Because
which is,
this is what was directed to be decided by this court
yes,
under, in the orders passed in the
yes,
application on the 11th.
yes, but that was, my lord, decided prima facie contrary to the provisions, my lord. Even if we barely read, my lord, the plain provisions of the act, my lord, it cannot be said that this clause 48 and 49 is a second arbitration clause. And, my lord, on the one hand, the tribunal is coming to a conclusion that
No,
the,
does the tribunal hold that this is the second arbitration clause?
yes, my lord.
Okay.
Yes, my lord. My lord, we'll take, my lord, to page 118, paragraph 8. Page 118, paragraph. If I may read, my lord. The relevant clauses of arbitration are clause 63 and 64 of the general conditions of contract. But a slight scope of misunderstanding has been created by the contract agreement itself, when it sought to incorporate some of the modified clauses of the general conditions of contract into the additional special conditions of contract. There is no such additional special conditions of contract forming part of the contract agreement. It will therefore be most appropriate to extract verbatim the clauses in question from additional special conditions of contract. My lord, then it starts to 45, my lord, 45.1 I have already read, my lord, which says that 63, 64 would be applicable. And my lord, thereafter, in the same continuation, my lord, there is 46 and then, my lord, 47, which is part of 64.7 on the next page. And those two clauses are there, my lord, 47, 48 and 49. So in addition to the bar of 20%, my lord, even if we go by the clause 48, it is very categorically stated that the contractor shall not be entitled to ask for reference of arbitration before the completion of work assigned to him. Here, apparently, my lord, at the outset, my lord, I have pointed out two communications by which the termination orders, my lord, they are subsequent to the prayer requesting for appointment of arbitrator, meaning thereby, my lord, the work was not completed by the contractor. Those two termination letters has not been put to challenge before the arbitrator. In fact, the claimant, my lord, approached under 11 even before the termination of the contract.
Yes.
And now if I may read paragraph 9 also, my lord, the relevant paragraphs of the impugn order. It is therefore evident that clauses 45, 46, 47 and 49 referred above relates to additional special conditions of contract forming part of the agreement. No, these are not additional special conditions, no, they are part of, my lord, 55.1 and it is in one chronological order. Clause 46 only refers back to the general conditions of contract and quotes certain clauses of the said general conditions of contract such as clause 26, 52, 63 and 64. This can be understood by the fact that just after 64.7, clause 47 is mentioned. This is because all the clauses like clause 26, 52, 63, 64 are contained within clause 46 of the additional special conditions of contract. So when clause 49 of the additional special conditions of contract refers to special conditions 16.2 and 3, it is only referring to clause 16.2 and 16.3 of the additional special conditions of contract. The clauses 16.2 and 16.3 of the additional special conditions of contract, which are quoted herein below. Now, my lord, 16.2 and 3 is, my lord, clause relating to program and completion period, which, my lord, would not be applicable because the work was not completed by the claimant. So prima facie, my lord, the reference to arbitration and the decision on the arbitrability of the disputes, which was referred to by the learned tribunal, my lord, prima facie, it is
No.
contrary to the bare reading of the agreement.
Mr. Counsel, you are, this is not, as I've said earlier, that it's not an application under 11.6.
Yes, my lord.
11.6 has already decided and has referred the matter to be decided by the arbitrator. This is not an order, this is not an application against an application filed under 16.
16, yes, my lord. That
Now, this is pure and simple a matter under 227.
my lord,
You are seeking to invoke the
my
jurisdiction.
lord, my lord.
Now, this invocation is it only on the basis of the interpretation of the contract?
Yes,
Clauses?
yes, on the basis of the prima facie interpretation of the contract, not, my lord, the merits. And what I am, my lord, trying to submit is that, my lord, the plain reading of the contract, prima facie, my lord, bars the contract. So far as the 20% issue is concerned.
There is a
the-
finding by the coordinate bench while referring the matter to arbitration that there are two views possible. There's a finding.
Yes.
So
But the other view, my lord, my lord,
whether that view, first view is correct or the second view is correct is a matter to be decided in appeal. Unless you say that no, reading this contract expressly it is barred or there is no jurisdiction to decide keeping in mind the quantum of the work or they have abandoned the work, so therefore there was no question of dispute. These facts were placed,
Yes.
not considered.
Yes, these facts were there, my lord. We have filed in a written objection. We have categorically pleaded those things. The tribunal ignored those facts, my lord, and rather held that the dispute is arbitrable. But to decide on the dispute as to arbitrable, this fact ought to have been taken into consideration. The two
Alright.
facts regarding, my lord, the 20% and the contractor has not completed the work, my lord. And before completion of the work, he has approached the London Tribunal.
Okay, anything more?
My lord, two more judgments, my lord, I will just, I will rely, my lord. That is 2018-17 SCC 607. My lord, United India Insurance Company Limited and another. Paragraph 10, my lord. Paragraph 10. I may read, my lord. The
Yes.
clause similar to the subject clause 7 of the insurance policy came for consideration before a three-judge bench of this court in Oriental Insurance Company Limited. After analyzing the legal principle expounded in a host of decisions, including decisions in Jumbo Bags Limited, the court opined as follows. It does not need special emphasis that an arbitration clause is required to be strictly construed. Any expression in the clause must unequivocally express the intent of arbitration. It can also lay the postulate in which situations the arbitration clause cannot be given effect to. If a clause stipulates that under certain circumstances there can be no arbitration and they are demonstrably clear, then the controversy pertaining to the appointment of arbitrator has to be put to rest. In the instant case, clause 13 categorically lays the postulate that if the insurer has disputed or
No,
not accepted.
the question is there in our mind,
My lord.
asking you, thinking aloud. If it is your case, if it was your case, that there is no arbitration possible in terms of a plain reading of the provision,
My lord.
why did you not go and appeal against appointment of the arbitrator by the earlier order?
Because, my lord, the order under section 11, my lord, interested the court to decide on the arbitrability. Therefore, my lord, we made all our submissions before the honorable tribunal on the arbitrability. And under the act, my lord, there is no provision to challenge. Therefore, my lord, we have come under 227.
So the only remedy is for you to go and appeal after the arbitration is over.
My lord, that would be, my lord, because we would argue on the merits of the case. Here we are saying, my lord, prima facie the contract agreement bars the 20% restriction, my lord, that has also been upheld by our court, my lord, ATW judgment that is holding the field. The principles would apply, my lord. And secondly, the contract agreement also expressly bars that before the completion of the contract, we cannot come for arbitration. These are, my lord, prima facie express conditions in the contract before a person can come before the arbitration. And this judgment, my lord, which I am relying upon, also, my lord, points to that effect that the conditions have to be agreed by the party. And therefore, my lord, subsequently in paragraph, my lord, it was held that the dispute which is not referable to arbitration being not covered by the clause cannot be over the subject matter of arbitration. And the remedy of the insured in this case is only to institute a suit. So, my lord, here the conclusion was, my lord, the paragraph 12. My lord, paragraph 12 also, my lord, I will read. Paragraph 12. From the line of authorities, it is clear that the arbitration clause has to be interpreted strictly. The subject clause 7, which is in parameteria to clause 13 of the policy, considered by a three-judge bench in Oriental Insurance Company Limited, is a conditional expression of intent. Such an arbitration clause will get activated or kindled only if the dispute between the parties is limited to the quantum to be paid under the policy. The liability should be unequivocally admitted by the insurer. That is a precondition in sine qua non for triggering the arbitration clause. To put it differently, an arbitration clause would leaven or invigorate only if the insurer admits or accepts its liability under or in respect of policy concern. This has been expressly predicated in the opening part of clause 7 as well as the second paragraph of the same clause. In the opening part, it is stated that the liability being otherwise admitted, this is reinforced and reinstated in the second paragraph in the following words. thus understood there can be no arbitration in cases where the insurance company disputes or does not accept the liability under or in respect of the policy. So therefore, my lord, in view of the clause, my lord, the court has dismissed the petition and given liberty to approach a civil court for, my lord, adjudicating the grievance. And my lord, here the claimant, my lord, he has already been paid all the amounts, my lord. I have just collected the details of payment, my lord, around 37 crores. He has already been paid out of the total contract value of, my lord, 34 crores. Entire amount has been paid, my lord. We are not able to understand what is the exactly the dispute before the tribunal. All the work so far, whatever work he has done, my lord, I have just collected the details, my lord. My lord, the final contract value was 39 crores and bill already paid before the termination of contract is 37 crores. And since the, my lord, the work was not completed, naturally, my lord, the bank guarantee and the performance, the security deposits were forfeited.
Yes.
My lord, the third page is the calculation which I have given. My lord, will see in the, my lord, the final contract value after termination is 39 crores, bill already paid is 37 crores. And my lord, the amount which has to be recovered because the work was not completed, because my lord, we have to get the remaining work done through other contractor.
We are not set to go into this. How
There is no
this
dispute,
relevant here?
my lord. I am just pointing out, my lord, there is no dispute. In fact, my lord, the arbitrator has, my lord, ignored all the conditions of the contract. And even before the termination of the contract, my lord, he has approached for arbitration. Therefore, my lord, the dispute is not arbitrable, my lord. That is a humble submission.
Yes.
That-
Yes.
I was wondering whether my learned friend has converted the court under section 34 of the Arbitration Act. My lord, this honorable court under 11.6 has considered whatever arguments he is advancing now about arbitrability were all considered. And the matter was referred to the arbitration. He has not gone in appeal against the arbitration order, section 11.6 order. That has attained finality. The matter went to the arbitration. He participated in the proceedings, filed his statement of defense, filed his counterclaim. Draft questions which are to be framed that were also forwarded. Questions have also been framed. He has not filed the section 16 petition also before the arbitrator. Now, he wants that on the basis of the order passed by the arbitrator tribunal, deciding the jurisdiction, this honorable court should sit there again, shall reconsider the decision of 11.6 and shall this honorable court, he is inviting this honorable court to examine as to whether the matter is arbitrable or not. Well, this issue is all in number of judgments of the apex court had been set at rest, that when the tribunal decides the jurisdiction question, then the only remedy is under section 34. Wherever the 22, 26 to 27 petitions were filed, the apex court has held, my lord, that those petitions are not maintainable. My learned friend has placed the judgment that this is arbitrable, this is not arbitrable. So that was at the stage of 11.6. And the subsequent judgment of this honorable court, well, there is no provision that the subsequent judgment which has come, that will nullify the judgment which was 11.6 which has been passed. Well, I will place two judgments because I'm not going into on the merits, the quantum, the amount, 37 crores he has paid to me out of 39 crores, might be 41 crores also, who knows. We are not here to decide the quantum. We are not here to decide that is for the arbitration and arbitral proceedings, not for this honorable court. I will also make, I will first of all see the judgment of the apex court. My lord, I've given my affirm opposition, if you'll also kindly.
Yes.
The lawsuit looks into page 284, my lord. The judgment starts. And I may take your seat to 288.
Yes.
The conclusion, my lord. We therefore sum up our conclusions as follows. The power exercised by, my lord, I may skip over, these are not required. You'll also come to paragraph 6, my lord, Roman 6. Once the matter reaches the arbitral tribunal or the sole arbitrator, the High Court would not interfere with the orders passed by the arbitrator or the arbitral tribunal during the course of the arbitration proceedings, and the parties could approach the court only in terms of Section 37 of the Act or in terms of Section 34 of the Act. Since an order passed by the Chief Justice of the High Court by the designated judge of the court is judicial order, an appeal will against that order lie only under Article 136 of the Constitution of India to the Supreme Court.
This is with reference to 11(6).
11(6). But my lord, this 6 is with regard to, my lord, that the orders passed by the arbitrator should not be interfered by the High Court, and only remedy is under Section 34 or 37 of the Act.
Yes.
Now the petitioner, having accepted the order of 11(6), is now saying that the matter could not have been deferred because of this arbitration clause, that clause, and that all those clauses were considered in the 11(6) order. If he had any grievance that the matter should not have been referred to arbitration, he could have approached the apex court on Article 136, challenging that order, which having not done, this honorable court is not going to sit over the judgment of this honorable court passed under 11(6) of the Act. Now, I may take your lordship to the judgment he placed before your lordship, my lord, at page 207. Look at copy to the more copy oscillator. Noting deep industry, more copy oscillator. Noting क्या हुआ? In fact, that is a quotation from the earlier judgment itself at page 45. When the Milord, I may read from this. Although this is a quotation from the earlier judgment which I placed before lordship,
Yes.
SBP, Milord, I placed before lordship. Paragraph 45, in fact, that is in that judgment.
SBP.
My lord, I placed earlier, Milord.
Yes.
It's paragraph 45.
45. This judgment has, I think, 21, 20.
I may take it to deep industry, Milord. Which starts from page deep industry. 318. 318 is relevant part, my lord. In SPP and Company Supra, this court, while considering the interference of the order passed by arbitral tribunal under Article 226 to 224 Constitution, laid down as follows. It is seen that some high courts have proceeded on the basis that the order passed by an arbitral tribunal during the arbitration would be capable of being challenged under Article 226 to 227 Constitution. We see no warrant for such an approach. Section 37 makes certain orders of the arbitral tribunal applicable. Under Section 34, the aggrieved party has an avenue for ventilating his grievances against the award, including any in-between orders that might have been passed by the arbitral tribunal acting under Section 16 of the Act. The party aggrieved by order of the arbitral tribunal, unless has a right to appeal under Section 37 of the Act, has to wait until the award is passed by the tribunal. This appears to be the scheme of the Act. The arbitral tribunal is, after all, a creature of the contract between the parties. The arbitration agreement, even though if the occasion arises, the Chief Justice may constitute it based on the contract between the parties, but the same would not alter the status of the arbitration tribunal. It will still be a forum chosen by the parties to the agreement. We therefore disapprove of the stand adopted by some of the high courts that any order passed by the arbitral tribunal is capable of being correction by the high court under Article 226 or 227 of the Constitution. Such an intervention by the high court is not permissible. The object of minimizing judicial intervention while the matter is in the process of being arbitrated upon will certainly be defeated if the High Court could be appropriated under Article 227 of the Constitution of India, under Article 226 of the Constitution against every order made by the arbitral tribunal. Therefore, it is necessary to indicate that once the arbitration has commenced in the arbitral tribunal, parties will have to wait until the award is communicated, unless, of course, a right to appeal is available to them under Section 37 of the Act and for the earlier extent. In so many clear words, the Apex Court has said that once either mutually or even if by the Chief Justice or the Judge Designate, my lord, the arbitrator is appointed, it will be deemed that it has been appointed by both the sides. And once it is appointed, there is no in between that my learned friend will come before Lordship and say that 227 and 226, I am exercising power, and Lordship should interfere in the matter and see that whether the arbitral tribunal has acted correctly or not. All these options are open to him in Section 34 after the award is passed. That is the scheme of the Act. Now I take the Lordship to the judgment, which your Lordship find it pays your last note. The page number ना? हाँ? तो है copy? Separate copy है? One copy yesterday, I am told that again, State of West Bengal versus Sarkar and Sarkar. Separately below. You don't have the copy? I can pass over, but it is all marked, my lord, in my copy.
Good for the court.
I will give one copy extra, my lord, to the Lordship.
Yes.
I will take it like Lordship is likely to. Paragraph 10, my lord.
Paragraph
10.
10. Yes.
It was the submission of the learned counsel for the respondent that the proceedings could not have been entertained by the arbitrator under section 16 of the Arbitration Act in the present controversy because of the orders passed by the High Court dated so and so. The appointment of the arbitrator was made in exercise of the powers vested in the High Court under Article 11 of the Act. The factual position depicted here above also, the orders referred to here above, leave no room for doubt that Justice so and so was actually appointed as an arbitrator by the High Court in exercise of the powers vested in the High Court under Section 11 of the Arbitration Act. That being the position, the learned counsel for the respondent is duly justified in a submission that the said order could not have been tested by the arbitrator while considering the claim raised by the arbitration appellant state of West Bengal under Section 16 of the Arbitration Act. Thus, viewed respective of whether Clause 12 extracted here above postulated the adjudication of the dispute between parties to an arbitrator, it is now not open for the appellant parties to it is now not open to the appellant before this court to raise a challenge to the order passed by the High Court appointing an arbitrator. There is another reason for we are not so to accept the prayer made before us on behalf of the appellant state, West Bengal, for raising the challenge to the order dated so-and-so passed by the arbitrator and the order dated so-and-so passed by the High Court. And that is that order dated passed by the High Court extracted above leaves no room for doubt that the appellant before this court factually requested the High Court to grant liberty to it to prefer a counterclaim before the arbitrator. In other words, the appellant prayer to the High Court on so-and-so was to permit it to raise on disputes by granting liberty to it to prefer a counterclaim before the arbitrator. Such being the position, the appellant cannot be now wriggled out of the aforesaid voluntary acceptance to have the matter adjudicated before the arbitrator. In any case, even Section 7(4)(c) of the Arbitration Act in such factual circumstances would lead to a same conclusion. Therefore, in the facts and circumstances of this case, though there is a dispute about the fact that against the claim raised by the respondent so-and-so before the arbitration, the appellant state as West Bengal has indeed raised a counterclaim, and having done so, it must be deemed to have submitted before the arbitrator request to adjudicate the claim as well. When both parties has approached the arbitrator and submitted themselves to the jurisdiction, arbitrary jurisdiction, independent of all of the factual and legal considerations, the arbitrability of the dispute was clearly made out under Section so-and-so of this Act. Now, in the present case also, my lord, the petitioner filed a counterclaim, the defense, and also gave a draft issues which arise out of in this case, and the issues were framed by the arbitrator. Now, having done so, by filing the present writ petition, in fact, he asking for a review of the order passed by this Honorable Court under Section 11(6) of the Act. And as you also is aware, any subsequent order passed by the High Court in another proceeding cannot have a bearing on the order which has already been passed. Even that is not a ground for review also. Who knows, the subsequent order will stand or not. The party may go to Supreme Court, it may be set aside. But your order has attained finality. You are not in a position to now say that order was not correct.
Have any counterclaims been filed?
My lord?
Have they filed any counterclaim
Yes,
before the tribunal?
yes, before the tribunal. I've got the copy. It was not in a proper form, so it has not been taken into account at all, even now, but they filed. That is not disputed. And my learned friend says that we have not filed petition under Section 16 of the Act. If you have not raised the objection under Section 16 of the Act, that means you have no grievance. Even if you have filed, you would have filed the Section 16 petition also. Then also, in my humble submission, my lord, the tribunal will decide its own jurisdiction, but that can be challenged only after completion of the proceedings. That is after under Section 34. Now you'll also see one judgment intercontinental. Yes. यहाँ copy दिया हूँ. I may take your lordship to para 19, my lord.
Yes.
At the outset, we need to state that this court's jurisdiction to adjudicate matters at the pre-appointment stage has been subject matter of numerous cases before the High Court, this court as well as the High Court. The initial interpretation provided by the court to examine issues extensively was recognized as being against the pro-arbitration stance envisaged under Section 96 Act. Case by case, courts restricted themselves in occupying the space provided for the arbitrator in line with the party autonomy that has been reiterated by this court in so, which clearly expounds that court had very limited jurisdiction under Section 11(6) of the Act. Courts are to take a prima facie view, as explained therein, on issues relating to existence of the arbitration agreement. Usually, issues of arbitrability validity are matters to be adjudicated upon by the arbitrator. The only narrow exemption carved out was whether the courts would adjudicate to cut the deadwood. Ultimately, the court held that the watchword for the court is when in doubt to do refer. This court concluded in so. So whenever, even if it is in doubt, the matter has to be referred. Now we'll also kindly see, my lord. In the bottom, my lord, 244.2. Usually subject matter arbitrability cannot be decided at the stage of Section 8 or 11 of the Act unless it is a clear case of the deadwood. The court under Section 8 and 11 has to refer the matter of arbitration or to appoint the arbitrator. The case may be unless a party has established a prima facie summary finding case of non-existence of the valid arbitration agreement by summarily portraying the strong case that he has entitled to such a finding. Now he tried before this honorable court, and this honorable court found that no, there is a case of doubt and it will refer to arbitration. Now he cannot agitate again the same issue before this honorable court to say that there is no arbitration clause. He made all the arguments before this honorable court, and the apex court said, whenever you are in doubt, refer it. Now you'll also kindly look into my lord.
So essentially what you are submitting is that once on the 11(6),
My lord.
the court has exercised its jurisdiction, appointing an arbitrator.
My lord.
Giving the liberty to the tribunal to decide jurisdiction will not permit any party to re-approach this court. If any parties agree,
Then after conclusion of the arbitration proceedings, Section 34 is there, and then Section 37 is there.
34 and 37,
37 is there. But in between,
and that order by which the tribunal was appointed, that is not,
that is not in challenge.
and they have also filed their
Counterclaim also participating in proceedings,
that they have subjected jurisdiction.
statement defense, and also issues framed, and they say we have not filed a petition under Section 16 of the Act also. Now, one judgment more, my lord, I will place before lordship, because all other judgments I find that my lord has no relevance, because that amounts to that making this court to sit as a, my lord, Article 226 instead of Section 34 petition. That I paid 37 crores, 39 crores was there, and all those things. Go before the arbitrator. Show all those things. इसको कॉपी है ना भवन भवन कहाँ है मतलब at page 298 I will take a lordship to my lord. Paragraph 5. In any case,
98,
my lord, it starts from 298.
page 300,
My lord, this is paragraph 5.
there are 5.
my lord.
Yes.
In any case, as you also got it,
That's para 4, yes. Yes.
my lord. In any case, the appellant appointed respondent to act as arbitrator for adjudication of the disputes. Respondent 1 preferred an application of the section 16 of the Arbitration Act 1996, so and so, disputing the jurisdiction of the sole arbitrator. On so and so, the sole arbitrator rejected the application and held that the sole arbitrator had the jurisdiction to adjudicate the dispute. Being agreed by the order of sole arbitrator, respondent 1 preferred so and so under Article 226 to 227 of the Constitution of India before the High Court of Gujarat. The single judge, while dismissing the special petition, held that so and so, the single judge, my lord, held that the application is not maintainable. Thereafter, Lordship mechanism, my lord, para 7, I think it will be 6 in your lordship, my lord. And aside the order,
Right?
Sir.
Para 7.
agreed in my case, my lord, para 7.
I agree, yes. Para 6. Yes.
My lord. Agreed by the order of single judge, respondent number 1 preferred latest pending appeal so and so of the High Court of Gujarat by impugned order allowed the appeal and observed as follows. I believe, my lord. As discussed in above, the contact is a worst contact and dispute is raised by the petitioner at the earliest available opportunity about the forum in which the dispute is adjudicated. It was an alien in so and so, the appellant denied that in view of so and so, when it is provided the provisions of the Indian Arbitration Act and other statute modification, therefore will be applicable. The respondent cannot appoint a sole arbitrator and thereafter cannot contend that now that the arbitrator is already appointed and he has already exercised power under the provisions of the Arbitration and Conciliation Act. The petitioner has to wait till the arbitration award is passed to challenge the same under section 34 of 37 Act, exactly which my learned friend is saying. Now, in this connection, my lord, the apex court will also find just above para 12, last line of para 12. But in your case, your lordship case, it will be, I think 11.
We need to know.
We need to note that the Arbitration Act is a code in itself. This phrase is not merely conflicting, but also a definite legal consequences. One such consequence is spelled out in section 5 of the Arbitration Act, which reads as under.
Yes.
This says, notwithstanding that the judicial forum is not there. The non-obstante clause is provided to uphold the intention of the legislature as provided in the preamble to adopt ministerial model rules to reduce the excessive judicial interference, which is not contemplated under the Arbitration Act. The Arbitration Act, itself gives various procedures and forums to challenge the appointment of an arbitrator. The framework clearly provides an intention to address most of the issues within the ambit of the Act itself, without there being any scope for an extra statutory mechanism or provide just and fair resolutions. We will also see para 15, Miller. In this context, we may state that the appellant acted in accordance with the procedure laid down under the agreement to the unilaterally appoint an arbitrator without respondent 1 amounting to a judicial challenge at this stage. Respondent 1 then appeared before the sole arbitrator and challenged the jurisdiction of the sole arbitrator in section 16(2) of the Act, which has not been done by them. Therefore, respondent 1 choose to impugn the order passed by the arbitrator under section 16(2) of the Act, though through a petition under Article 226, 227 of the Constitution. In the usual course, the Arbitration Act provides for the mechanism of challenge under section 34. The opening phrase of section 34 reads as under. So section 34 has been quoted. Thereafter, you will also see below para 17, the last paragraph below. It is therefore prudent for a judge not to exercise discretion to allow judicial interference beyond a procedure established under the enactment. This power needs to be exercised in exceptional rarity, where the party is left remediless under the statute or clear bad faith shown by some of the parties. The high standard set by this court in terms of the legislative intention to make the arbitration fair and efficient. In this context, we may refer to the deep industry, which I referred to, my lord, where in interplay, section 5 of the Arbitration Act 227 Constitution of India, it was held as under. And you also may skip over para 19, my lord. para 19, my lord.
Yes.
In the instant case, respondent one has not been able to show exceptional circumstances or bad faith on the part of the appellant to invoke the remedy under Article 227 Constitution of India. No doubt that the Article 227 was broad and pervasive. However, the High Court should not have used this inherent power to interpret the arbitral process at this stage. It is brought to one notice. It is brought to our notice that subsequent to the impugnment order of the sole arbitrator, a final award was rendered on merits which is challenged so and so. You'll also may draft speech over and we'll come to middle of paragraph. The last paragraph, you know. Last slide. If the courts are allowed to interfere with the arbitral process beyond the ambit of the enactment, then the efficiency of the present process will be diminished. If the High Court did not appreciate the limitation Article 226 and 227 of the Constitution and reason that the appellant has undertaken to appoint arbitrator unilaterally, thereby rendering respondent one remediless. However, a plain reading of the arbitration agreement points to the fact that the appellant herein had actually acted in accordance with the procedure laid down without any mala fide. Where is the question in the mala fide on our part? Respondent number one did not take any legal recourse against the appointment of the sole arbitrator and rather submitted themselves before the tribunal to adjudicate on the jurisdiction issue as well as on the merits. In this situation, respondent one has to endure to the natural consequence of submitting themselves to the jurisdiction of the sole arbitrator, which can be challenged through the application under Section 34. It may be noted so and so. And the last, my lord, para 25. It must be noted that Section 16 of the Arbitration Act necessarily mandates that the issue of jurisdiction must be dealt with by the tribunal before the court examines the same under Section 34. Therefore, so and so. In view of the above, we are of the considered opinion that the High Court erred in utilizing the discretionary power available under Article 226 and 227 of the Constitution of India. So and so the above. Well, under those circumstances, in my humble submission, this petition on Article 226 is clearly not maintainable. And the arguments which my learned friend is making, these are all beyond the scope of Article 226 of the Constitution of India. All these arguments he can make before the arbitrator. Who knows, he may succeed in the arbitration proceedings. They may have to go in Article Section 34, who knows? And even if it goes against him, he can go to Section 34 petitions. But once the 11-6 order had its finality, on the basis of that fact that the subsequent order has come, wherein also I'm told that the earlier order was not referred to. Perhaps if the earlier order of 11-6 would not have been brought to the notice of the honorable judge, the matter would have been referred to the arbitration.
Yeah.
So in my humble submission, my lord, all those judgments which my learned friend is citing and showing, nowhere 226, 227, nobody disputes that your lordship has extensive powers. Your lordship can, your hands are very long, your lordship can do it. But in which matters it should be done and which matters should not.
We would like to believe that we have extensive power, then we can do it.
My lord, I
Question
never,
is, should we?
my lord, the 226 power, nobody can say, my lord, that your lordship doesn't have the power. Your lordship have all the powers. But the question is that,
Whether we should do it.
my lord, the maintainability and entertainability, my lord, that the apex court has said, the maintainability and entertainability are two different concepts. Even if tomorrow he says moon is mine and file a 226 petition, it will come up before your lordship. That whether moon is there or not, but whether your lordship will like to do it or not, that is a different issue. And in fact, in my humble submission, my lord, the approach which the railways, I think the railways are taking, my lord, it is unheard of. You don't file petition under Section 16. You don't file the SLP against 11-6 order. You participate in the proceedings, you file counterclaim, you file defense, you file draft issues, and now you come up and criticize the arbitrator. The arbitrator has done this. Do it. in section 34 when you do it, when you go there. Still, he has the jurisdiction only that has been decided. Why take it that it will go against you? Only the tribunal has decided only that I have the jurisdiction. They have not decided the matter. The matter may be decided in favor of the railways. And if it's not decided, go in section 34. You cannot bypass and all the statutory scheme and thereafter set at rest, my lord, and all the Supreme Court judgments which clearly says where the division bench, my lord, of the Gujarat High Court, my lord, interfered, the apex court has set aside. My humble submission, I am not making any submissions of the, my lord, 37 crore, 39 crores, barriers, and much. I am not making submissions because according to me, these submissions are not called for in these proceedings in Article 226 of the Constitution. No bad faith, no malafide on the part of the respondent has been alleged. It is interpretation of the argument which the arbitrator has done. And our interpretation of the arbitration agreement, as your lordship knows, even 34 also, the apex court has said that interpretation of the agreement, that is not a subject matter of under Article 34 of the Act also. That much finality has been given to the arbitrator with regard to the interpretation of the agreement. And if assuming, my lord, they were so willing to come up before lordship, after section 34, they can come up before section 37 before lordship, your lordship will get subject to the restrictions which are there in section 34 and 37 of the Act. In my humble submission, my lord, this writ petition is liable to be dismissed with exemplary cost for not only wasting the time of precious time of judicial time of your lordship, but also the cost which has been incurred by the respondent. That is my humble submission.
A small rebuttal, my lord. So far as, my lord, this statement made that we have filed statement of defense and counterclaim. My lord, this writ petition was filed on 1st of February. But subsequent to that, my lord, we have filed the SOD because that is the process before the tribunal. We cannot skip the order of the court. So it's not that, my lord, after filing SOD, we have challenged the order. The order on the decision of the arbitrability, my lord, the tribunal has decided. And during the course of the hearing, my lord, we have to challenge it.
So after filing which writ petition?
My lord, this writ petition was filed on 1st of February.
This
And
writ petition?
yes, my lord. And my learned the senior my lord is saying, my lord, that we have filed SOD also. The SOD was filed, my lord, on 7/4, subsequent to the passing. So immediately, yes.
You filed?
Yes, my lord, that we have to file because, my lord, there is an order of the tribunal that we cannot skip the procedure. So that we have to file it, my lord. But immediately after the decision on the arbitrability, my lord, we have come before the court to challenge it under 227, my lord. And so far as, my lord, the other point is that, my lord, that, my lord, one more submission I just want to conclude by saying that, my lord, the tribunal, while deciding on the issue of arbitrability, my lord, in one part has, my lord, held that the claimant do not have right to, my lord, claim right to demand for arbitration invoking 64(1). It is the admitted fact that, my lord, clause 63 and 64 is the only clause under the contract governing the arbitration. And while adjudicating on the issue of arbitrability, my lord, the tribunal had come to conclusion that the dispute is not arbitrable on one part. But, my lord, while adjudicating on the issue of admissibility, my lord, the arbitrability of the dispute, the tribunal went ahead to, my lord, make the dispute arbitrable in view of 48 and 49, which, because railway is the, my lord, here they have drafted the contract, my lord. We know that this contract is not an arbitration clause. Well, dispute may be referable to arbitration, but it should be under the clause which is providing for arbitration. Well, that is my humble submission.
Well, only one thing, my lord. My learned can say that in February he filed the petition. Subsequently, your lordship find the orders. The order, interim order was not passed. The maintainability of the petition, the court has said that maintainability of the petition is an issue. And the fact that the interim order was not passed, and subsequently he has filed a counterclaim, the defense. Whatever may be the defense has been filed, counterclaim has been filed before or after, that is not the issue. But you also find the earlier orders of this honorable court where the issue is that maintainability of the petition. That was the issue on which the court was looking into it, and no interim order was passed.
Yes.
That is my humble submission, my lord. I am not going to make submissions on the other issues which my learned can do.
But may I pray for, I will also submit the short written argument if Lordship permits, 1 page, 2 page, if Lordship permits,
Written submit.
written submission. Very short.
I don't think that I need to file a written submission because I rely on the three judgments. So
We'll keep it for 27th. Try and pass an order. 27th of
July,
June. Before closure.
No.
because
27th.
the interim order, my lord, that's why
That's why
Yeah.
we are conscious of that. Why on pass an order on 27th,
Right.
not 27th. Attempt will be made to dispose of.
28th is the last day.
That's what we are trying because 25th, we have other matters fixed. Like 27th, the board is already filled up.
26th, my lord,
Sorry, 20.
26th.
Last day.
All right. 26th, we'll
Well,
try.
Little better, my lord.
26th.
Right.
But it is a miscellaneous day, so we don't,
At 2 o'clock.
we'll try. 26th. But you file your written
My
submission,
lord,
whatever
before
you have by this week,
My lord,
and serve them copies.
my lord.
I'm obliged, my lord.
But when documents that have been listed on 26th of June for further orders.
The interim will continue.
I interview
Well-
till the next day.
My lord, you may mention that the matter has almost been heard, otherwise
Council have been heard.
Right.
Parties are at liberty to submit an argument.
Well.
And listed again 26 for.
Public.
Next date may be Lordship 25th of July as per consensus.
Sorry,
25th of July. Pleadings has already been completed, my lord, in this matter. Maybe for taken for final disposal of.
25th of July.
Yes.
How about 30th?
As per convenient of
30th July? 30. Item number
12 and 13.
12 and 13 at the joint request. It is directed listed on 3007/24. As prayed.
There's an interim that we can.
Interim order passed earlier will be to the next.
I think it's on next.
Then let it come next week, 24th. List on 24th. 24th.
My lordship, last order is ended note sheet, my lord, 13/6.
Yes, what instruction?
Lordship, we have to complete the project by 26/7/24. And already 79% work is done. And Lordship, and other tenant of this building has already vacated, Lordship. The Pirista has done. And they have 6 1 year time in last year.
No,
That
that's
is-
all right, but if you if you are so hard pressed for time, then you have to find a way to commensurate the customers of the bank. How soon can you
My
shift?
lord, the alternate premise on wartime footing works are going on. We
No,
are
but how
undertaking
much,
round the clock.
how much time is
My
required?
lord, 2 months will be maximum.
that is-
By, this is June already gone. July, August, my lord, we will complete and
Why
we'll shift.
26? Why,
And my
why-
lord,
why you
another,
say 26?
26/7, Lord.
Why?
It is time bound, Lord. They have to complete, otherwise escalation charges.
my lord, my instruction is,
This is my instruction.
it
Lord.
is a straight up length road. Now, these small demolition and clearance are going on, my lord. The actual construction work of widening and extending, then rolling, then there is a, there will have to be a tender. All these things are there, my lord. And only small stages are back. They can do anything at any other place. That doesn't.
Last 1 year, they have taken time, Lord.
Yes, Mr. Gogoi,
My lord. For my information, my lord.
we'll give them 2 months time,
No,
60 days from
If
today.
it's, I undertake.
That's what, my lord, before that, my lord, let them sit with the authorities. And let the petitioner sit with the authorities, because before the deputy commissioner, he committed that in 7 days, he will complete it.
He is with a bulldozer, my lord.
We are undertaking.
Our undertaking before your lord.
No, that is why we wanted the instructors.
But that specific time, my lord, within which he
No,
will,
Yes,
you were permitted to visit the place and find out
my lord,
what is
that
the-
report has not come. It's not
Then-
come.
let it come, let us find out what is the stage then.
Yes, then Lord, she will fix it 2 months or 3 months, otherwise today, it's come by. But in the meantime, they must continue their, my lord, process for. my lord,
Wartime footing.
shifting it.
In the
We
new place,
were
wartime.
thinking of disposing of this petition today by giving them 60 days time to vacate the premises. Subject to your, whatever your report says,
Lord, she will fix it on Monday. In the
Monday,
meantime, let them continue, my
all right,
Piecemeal.
Monday,
lord. Monday or Friday, my lord.
let it be in Monday, let the
Very
report come.
rapidly, my lord.
Even then,
It's
my
for
lord,
your
let them
lordship.
continue.
But my prayer is, my lord, absolutely, I have stated. The
No,
construction,
you are under protection. Let it come on Monday, let us see if the
Yes,
report
sir.
comes.
Yes.
We directed them to visit your places and find out.
that way most welcome, my lord.
Yes, so
Works
what-
are going on.
what steps have they taken?
And from our side, undertaking is for 60 days.
Lord,
Putting
she will
back at-
reflect that also, my lord, will convey to our authority. That they are proposing to, my lord, shift within
60 days.
That may be reflected in the order.
And it counsel to the parties have been heard. The counsel
days
to
from
the
today.
respondents submit that the report called for has not yet been received. He submitted the matter be listed again on Monday, 24th. So meanwhile, Mr. Borbora, and the senior counsel, listed by him, submit that work
In the
going
alternate
on
premise.
in war footing, the alternative premises, so that the bank can shift its office premises, the alternative location, which has already been fixed. So he submits that with a period of, they undertake to submit, and they propose to shift to the alternative location within a period of 60
2
days
months from today.
from today. Let the matter be listed again on 24th for instructions from the respondents.
And meanwhile,
While the interim order passed earlier, we continue till the next 8 days.
if their revenue officers want to visit our alternate premise,
The
most welcome.
respondents are permitted to visit the premises of
Alternate premise.
the proposed premises where the HDFC Bank petitioner is proposing to shift to
Where
take
we
a
are
stock,
constructing, renovating, my lord, no?
take a stock of the works stated to be undertaken by the bank. They are permitted to do so. List on Monday.
Lovely, sir.
Okay. Hearing, I think, 15 to 53.
Yes.
Maybe I am prior, my lord, because the government has submitted additional affidavit, my lord.
in item number 18. So, my lord, there is some new facts they have brought it. So I have to file rejoinder, my lord. It's required, my lord, some new documents they have been incorporated. And
You want time, you're appearing in item 18.
yes, ma'am, 15, 18, 22, 24, 27, 28, 29, 30.
Government has filed it in item 18, Mr. Borbudari.
No, my lord, apart from item 18, we have also filed similar affidavits in other items also. Now, my lord, some discrepancies were there. We took the leave of this honorable court. As on today, my lord, the pleadings on the part of the government is over. Now it is for them, my lord. If they want to file any rejoinder or if they start their argument, my lord, they can start.
Rejoinder is required, well, otherwise they have come up with a new story. Now they have sent a proposal to the government for recalling of
Whatever
the.
it is, you want to file a rejoinder.
Yes, ma'am. Yes, ma'am.
Okay.
Let
Learned Counsel, Mr. S. Na, Mr. Bina, submits that government has filed an additional affidavit which to bring on record certain facts, new facts, which were earlier not there. Therefore, the petitioners crave leave to file rejoinder. How much time do you require? 2 weeks.
Weeks, ma'am. Weeks.
The petitioners pray for 2 weeks time, 2 weeks further time. Let the matters be listed in the month of July on a date fixed by the legislature.
I pray for a fixed date, if otherwise not inconvenient, my lord, with all respect, my lord. Let them complete their part, my lord. In the meantime, my lord, we'll go for a final hearing, my lord. Because lordship has been hearing this matter time and again.
30 July.
30 July.
It will be listed again on 30.
I'm so obliged.
30.
30.
30. Obliged.
I'm so obliged.
Wait, please, sir. My lord, in both, my lord, since Leonard Senior Counsel Mr. Das appeared in this, Das appeared, my lord. So since he's not here and Leonard AG also appeared, he's also not here. So we have
In
agreed on a
54.
fixed date. Yes, my lord. We have agreed on a fixed date, my lord. Can it be on 38? Since one case is already fixed on 38.
All right.
38th of July.
38th of July at the request of the council. It's on 30th.
My lord, there is an interim order.
Interim order passed at
Obliged.
the next date fixed.
I'm so obliged, man.